June. Wait.
Weekly list, item number 1.
ये ଅଛନ୍ତି ଡାକି ଦିଅ କରିବାକୁ। What is your item number?
14.
214. Bar for 214. My anticipatory bail has come to me earlier. Okay. So that is 3065 of 2020. That one of the offenses under section 307.
During the process of marriage process, and I have all the injury reports, and that the injury and the presentation not named in the
An FIR Rahul Banka और Probin Bag. हाँ.
And so far the Probin Bag is concerned, my lord, Honorable Justice, my lord, A.K. Mohapatra, please to allow his bail application, activity bail application.
The FIR named accused.
You can see, he is able to number 12600.
And unless it account ଦଉଛନ୍ତି. देखिए अच्छी नहीं annex ହେଇଛି କାଇଁ but you said that the injuries are simple in nature.
I have annexed the injury report, my lord.
Who are the injured persons?
There are from Illinois, my lord. I have annexed all the injury report starting from page 13, my lord. Annex of 1 series, my lord, page 13.
Okay. TP Rajeshwar Raju.
Page 14 is the relevant.
Simple injuries.
Page, my lord, page 16, my lord. Another person,
TP Sashwati Raju. Okay, then simple. It has are simple. Simple in nature, right? Then
my lord, page 17, 18 is relevant from the last person.
TP Sindhuja. Simple in nature.
Then my lord, page 19, my lord.
J. Nagendra. Also simple injury. J. Srikanth. Okay. Okay.
The person name may not he actually another accepted well by this one court, my lord, and the person not named it has subsequently to gain others his name has been found. And the occurrence will be
Yes, Mr. Das. Say FIR named accused je bail le galaani. ଆଉ injuries ଗୁଡାକ ସବୁ simple ଅଛି ଆଉ ୟା ନା FIR ରେ ନାହିଁ ଯାଉ ଲେଖନ୍ତୁ ABLAPL number 7466 of 2023. The Learned Counsel for the petitioner submitted that the petitioner has not been named in the FIR as an accused, and the FIR named accused Praveen Bagh alias Bagha has been directed to be released on bail in ABLAPL number 12600 of 2022 as per order dated 29/9/2022. He produced the copy of the bail order which is taken on record. He further submits that all the injured persons in this case, namely, injuries have sustained simple injuries, which should be evident from the injury reports annexed to the bail application, anticipatory bail application. And therefore, the bail application of the petitioner may be favorably considered. Learned counsel for the state opposed the prayer for bail, considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, release of co-accused on anticipatory bail, fact that the injured persons have sustained simple injuries. I am inclined to release the petitioner on anticipatory bail. In the event of arrest, one shall not be released on bail allowed. Yes. Yeah, just a minute. 353. Ah.
Verified. Address and criminal antecedents have also been verified. This is for order to be passed.
All right, Mr. Just call for those two files. 353 और 354. कौन जो लोकल सिक्योरिटी बाहर लोक बोधे आपण कोन कहउजन तांको इंस्ट्रक्शन वेरीफाई हे जाईची बेली मगई दियंतु देखि दो yes you please wait yes Mr. Chand.
item 339 concern
339 just a minute.
Last week of the
Mr. Manas Kumar Chand, Learned Counsel, appearing for the petitioner na petitioner Johnny petitioner seeks permission to withdraw the application accordingly. ABLAPL disposed of as withdrawn.
So for 86.
86.
108.
Yeah, just a minute.
108. 108.
ମୁଁ ତ ଅଛି ମଗେଇ ଦିଅନ୍ତୁ ଫାଇଲ ମଗେଇ ଦିଅନ୍ତୁ
pardon
ହଁ ସେ ଦେଇଦେଲେ ସେ ମଗେଇ ଦେବେ 86
108 163 179 181
ଆପଣଙ୍କର ମିଷ୍ଟର ପଣ୍ଡା ଫାଇଲ ନମ୍ବରଟା ଦିଅନ୍ତୁ
143 242
ସେପଟୁ ପଳେଇ ଯାଆନ୍ତୁ
143
242
188
ଆପଣ କେତେ ନମ୍ବର
2019
20 ହଁ ନମ୍ବର ଦିଅନ୍ତୁ ତାଙ୍କ ନମ୍ବର ଦିଅନ୍ତୁ ସେ ଫାଇଲ ମଗେଇବେ
192 ଆଉ 242
ଆପଣ କେତେ
206
206
I'm a BC minor item 15. Item 15 is interim bail. I am come to the court and argue my lord. Just call the request the learner state council to call get the file my lord.
item number 15 ଟା ମଗେଇ ଦିଅନ୍ତୁ
My lord, oblige my lord.
item
15 number Budhiya, Mr. A.K. Budhiya.
ଅଛି ଭାଇ।
Achi, right.
My lord, I am coming to the court, my lord.
Yeah.
pardon, serial
नहीं नहीं जो ये आश्चंती से
serial number 1 टा अछि
हाँ serial number 1 तो फाइल थी वो serial number 1 टा देखिले मिस्टर दास
Well,
कुंतु कौन है छे
victim already married man, all 2 children.
नहीं जी आश्चंती तांकर मुख करंतु 240 कौन है कौना दी को
242, my lord has earlier rejected
हाँ
the prayer of the bail of the petitioner on the ground to examination of the material witnesses.
just a
The
minute that
co-accused
is
persons have been granted bail. I have annexed the bail order.
242 है मुक्का alias मुकेश
Mukesh
Madkami model ta dekhe in counsel for the petitioner submitted that the petitioners are in judicial custody in so and so. They have been charge sheeted under section so and so. There are two deceased in this case who are so and so, and there are no eyewitness to the occurrence. Therefore, the bail application of the petitioner may be favorably considered. State, on the other hand, produced the case diary and stated that the informant Mukka Madi, who is the son of both the deceased, has stated extrajudicial confession made by the so and so before him, with the petitioner stated to have assaulted both the deceased to death. Okay. Further noted, okay. Okay. तो आपको लिबर्टी दिया ही थला जे इन्फॉर्मेंट मटेरियल विटनेस एग्जामिन हला पर मैं इन से कौन हला किछि
पर co-accused bail order to manage करिछि
नहीं
subsequently co-accused the exam नहीं छथि the statement
एक्स्ट्रा जुडिशियल कन्फेशन ने कौन अछि था वागला कौन
co-accused bail order
हाँ लक्ष्मीधर माडकामी को मु बेल दी हाँ
मुकेश मडकम stands on same footing.
सेम फुटिंग extrajudicial confession from so before him and the petitioner stated to have assaulted so Mr. दास या धीरे जेतबेले प्रथम आस्थिले 2021 मसिया दी जण आक्यूज आस्थिले लेट अस से ए एंड बी को एटा डायरेक्ट एविडेंस नहीं जदियो सर्कमस्टेंशियल एविडेंस रे एक्स्ट्रा जुडिशियल कन्फेशन ने दी जनकर ना थिला टू हैव असॉल्टेड बाय लाठी एंड स्प्लिटून सेतपई बेलटा रिजेक्ट हेतला 2021 से से जो ना एक्स्ट्रा जुडिशियल कन्फेशन ने थिला लेट अस से इट बी subsequently approached this court and he has been released on bail in view of the development made तेणु वर्तमान देखा होची जे ए और बी सेम फुटिंग रे अछंती तेणु बी रिलीज हे जाईची ए को से कहउचंती से ग्राउंड रे जाऊ बोली देखंतु हार्ड द लर्निंग काउंसिल फॉर द पिटिशनर लर्निंग काउंसिल फॉर द स्टेट Learning counsel for the petitioner submits that the petitioner is in judicial custody since 28/6/20 Kodiye, and he has been charge sheeted under section 302 by 34 of the Indian Penal Code. The bail application of the petitioner, along with one Lakshmidhar alias Lakama Madkami, was rejected in BLAPL number 7520/2020 as per order dated 11/6/2021. However, liberty was granted to the petitioner to renew the prayer for bail after examination of the informant in the trial court. Learned counsel submitted that after examination of the informant in the trial court as PW1, taking into account the improbability feature in his evidence comma, this court has directed him, लिखिले ना लक्ष्मीधर ताको, this court has directed the co-accused Lakshmidhar Madkami alias Lakma to be released on bail in BLAPL number 11632 of 2022 as per order dated 36/2023. He further submits that since the petitioner is similarly situated in view of the period of detention of the petitioner in judicial custody, the bail application may be favorably reconsidered. Learned counsel for the state opposed the prayer for bail. However, doesn't dispute that the petitioner is similarly situated like the co-accused Lakshmidhar Madkami alias Lakma as per the evidence of PW1 who has been released and stopped. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, absence of any direct evidence, nature of circumstantial evidence, the evidence of PW1 taking into account the period of detention of the petitioner in judicial custody and the release of the co-accused on bail, I am inclined to say PW1 evidence ta de diyantu. Achi PW1 ha
madness court.
Korichan to I am inclined to release the petitioner. All right.
Five minutes. 253
हाँ लगी 5 टा अच्छी बोले सेटा भी 5 हाँ गोटे गोटे नबर
दुईटा को नहीं
कोडा
दुई
हाँ दुईटा को
item 2
हाँ कौन एज को
item 2 your lordship it is after this your lordship 5 for 2020 your lordship.
ठीक है
Your lordship for a moment your lordship kindly see the order stated your lordship's order 36
36/23
6
एसी टा टिके कमै देबे
स्टेटस रिपोर्ट टा कॉल
एसी टा बंद कर दियो ना जरा अछि तो ना learned counsel for the petition submitted. The petitioner is in judicial custody since so and so. He has received instruction that out of 14 charge sheet witness, only one witness has been examined in view of so and so. Status report magaitla kon hala kon
thereafter your lordship's order thereafter another 2 witnesses have been examined. So I have already solved the question copy of I will be the question copy. That is your lordship PW lordship 2.
क्या डिपोजिशन कॉपी तो नहीं देख
I have solved on each side one much.
देखिले डिपोजिशन कॉपी का है था फाइल अच्छी देखिले डिपोजिशन कॉपी दे इसे लगी हाँ हाँ नहीं दे ही चंदी नहीं डिपोजिशन कॉपी अच्छी नाही को चंदी यदि अच्छी अपन बार दो ना दी कौन हला कुंदु
Your lordship in the PW2 your lordship that is Nixia number Nixia Shah.
No, he has not stated anything against you.
The accused present inside the document who is a resident of fine year village. In this case, your lordship is not stated.
Okay, he has not stated, even including PW3 has also not stated.
Yes,
but who are the other witnesses, material witnesses are to be examined? That is BLAPL number 8369.
Yes.
The deceased was, there was love affair between the petitioner and the deceased. and the deceased was found missing since 19/3/2020. Her husband lodged a missing report in the police station thereafter. So and so, okay, the dead body was recovered from the well of one so and so. UD case registered during a UD case inquiry. Okay, FIR was lost. There are no such clinching stones. Okay, directive. Learned counsel for the state, on the other hand, submitted that the CDR from so and so to indicates that there are a number of telephonic conversation between the petitioner and the deceased. He further submitted that at the instance of the petitioner, when the well was dried off, money purse and Gramya Bank passbook of the deceased and a sum of rupees so and so odd and her chappal were recovered. But Rakesh Shukla had seen the petitioner in the company of a lady on the date of occurrence. So ये evidence गुड़ा थिला आपन पाटे against it.
There is a out of 14 witnesses, you got 3 witnesses in adjournment. Process the so on
एमन किछ कहले नहीं, तीनटा witness किछ कहि ना दी.
so you lordship previous way you lordship directed to examine the witnesses after renew the petition. Thereafter you lordship section on the lordship petition is custody
5/4/2020, 3 years 6 months ହେଲାଣି. ବର୍ତ୍ତମାନ ପର୍ଯ୍ୟନ୍ତ କେତେ ସାକ୍ଷୀ ହେଇଛନ୍ତି?
ଗୋଟେ ହେଇଥିଲା your lordship's order after 36/2023 thereafter your lordship on 20 August 2023
କଣ କହୁଛନ୍ତି? Are the learned counsel for the petition, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 5/4/2020. He has been charge sheeted under section 302201 of the Indian Penal Code. When he approached this court earlier in BLAPL number 8369 of 2020, the bail application was rejected. As per order dated 23/3/2021, and liberty was granted to the petitioner to renew the prayer for bail after examination of the material witnesses. Learned counsel further submits that there is no direct evidence in this case, nor any clinching circumstantial evidence, and in the meantime, out of 14 charge sheet witnesses, 3 witnesses have been examined and they have not stated anything against the petitioner. He has produced the deposition copies of the witnesses which are taken on record. Learned counsel for the state opposed the prayer for bail, considering the submission, nature of accusation against the petitioner, nature of evidence adduced so far in the trial court, period of detention of the petitioner in judicial custody. I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail allowed.
141 minor.
Number they don't say mage. Tapur kundu 5 number. Yes,
my lord. All total, my lord, 5 accused persons. 4 the accused persons granted bail by the Sunil Court by Lordship, my lord. I'm giving the order and also the evidence of Pidol 2. Pidol 2 is a victim, my lord.
ठीक है. आगुर रिजेक्ट ହେଇଥିଲା ନା?
ନାଇଁ ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଆରଏସ୍ କୋ ଆକ୍ୟୁଜ ମାନଙ୍କ ଦେହରେ ରିଲିଜ ହେଇଛି।
ଆଚ୍ଛା, ଗୋଟେ ଜଗଦୀଶ ମହାନନ୍ଦା କଣ ଯାଇଥିଲା?
ଦେଇ ସବୁଟା ଦେଇଛି, ଅର୍ଡର ଦେଇଛି।
164 statement of the victim and the nature and gravity of the accusation. I am not in ସେଟା ଥିଲା। ଆଚ୍ଛା, ରିଜେକ୍ଟ ହେଇଥିଲା ଯୋଉଟା, ଏଇଟା କଣ ହେଲା କୋନ?
This case, my lord, the petitioner is lady, my lord.
State council को ଦେଇଛନ୍ତି।
Custody since my lord 2/8/2022, 2/8/2022. And in fact, in this case, my lord, the allegation against the petitioner called the victim to a hotel. Thereafter, taken the victim with him in a auto rickshaw and gave her roti and chicken, my lord. Thereafter, the other co-accused person committed a gang rape.
No, the offense is 1 under section 376D.
My lord.
So you come to the victim has been examined.
Examined Pidol to the evidence.
All right.
She has not identified any of the accused persons.
Just informant is my father. I am the victim of this case. I know accused Sujata, who is present in the door. Oh, I do not know the other accused persons. All right. Not identified.
He facilitated to the.
ତାମାନେ ୟା ନାଁରେ କିଛି କହିଲାନି
ନା ନା କେବଳ କହିଛି ଆକୁ ଚିହ୍ନିଛି ବୋଲି କହିଛି।
କୋଉଠି ଚିହ୍ନିଛି ବୋଲି
ହଁ କହିଛି ଆକୁ ଚିହ୍ନିଛି ବୋଲି ସୁଜାତା ଜାଣିଛି ବୋଲି ଆଇ ନୋ ୟାକୁ ସୁଜାତା ଅନ୍ୟମାନେ ଜାଣିନି ୟାକୁ ଜାଣିଛି କେବଳ।
ୟା ନାଁ କଣ ଓ ସୁଜାତା
ସୁଜାତା
ହଁ ସୁଜାତା ଆଚ୍ଛା ଇଏ ହଉଛି ସୁଜାତା
ଆଜ୍ଞା
ଆଚ୍ଛା
also
just a minute. One day the accused Sujata came to home along with one Anjali Didi, and after some time they both went back. After 2 days accused Sujata again came to our house in the afternoon in absence of my father, and while I was alone she told me to go to the nearest shop for having tea. I accompanied her to the shop. Sujata insisted me to go to the other place, to which I refused. She repeatedly requested me to go with her. We both went in an auto rickshaw, moved around different places, 7 or 10. At 10 p.m. we reached in an open place where many numbers of trees were standing. Sujata called someone over phone. About 3 to 4 persons reached there with whom Sujata discussed secretly. Sujata brought roti and chicken in a packet. I took the above food. After some time, I realized that I am little intoxicated. The above person guided us to another place. Sujata and me followed them in the auto rickshaw. I requested accused Sujata to drop me at my house, but she did not listen to me. The above persons pulled me from the auto rickshaw and raped me one by one. I became senseless. On the next day, I found myself at Burla Hospital. Father was not there. I feel him so and so. ଏଗୁଡା କଣ ବେଲ୍ ହେଇଯାଇଛି
ସମସ୍ତେ ବେଲ୍ ପଳେଇ ଏକ୍ସେପ୍ଟ
କଣ କହୁଛନ୍ତି ମିଷ୍ଟର ଇଏ ରହିଲାଣି 2/22 are the London Council for the Petitioner and Council for the State. The London Council for the Petitioner submit that the petitioner is a lady and she is in judicial custody since 2/8/2022, and co-accused persons have already been released on bail by this court in BLAPL number 4098 of 2023, 6927 of 2023, 6929 of 2023, 6932 of 2023. And the victim, having been examined as PW2 in the trial court, has not identified the accused persons in the court in the dock except the petitioner. The Land Council submits that in view of the role played by the petitioner, as per the statement of the victim, the ingredients of the main offenses are not attracted against her. And in view of the proviso to section 437(1) CRPC, the bail application may be favorably considered. London Council for the State oppose the prayer for bail, considering the submission, nature of accusation against the petitioner, nature of evidence adduced by the victim being examined as PW2 in the trial court, release of the co-accused persons on bail. I am inclined to release the petitioner on bail allowed.
Item 10. Item 10, man.
10 Tata.
My lord, my
Interim application has been rejected, and that my lord, I have filed a bail application for interim relief, my lord. Mother of the petitioner, my lord, is the communication matter. Last order is also directed my Ilana to take instruction.
कौन आसिला इंस्ट्रक्शन किछि
He then
आगुरी टाको निया हितला
निया है नथला खाली दुई थर कहितले नै आसु
अच्छा ओरल इंस्ट्रक्शन दिया हितला मां को देह खराब पिटिशनर रो तो मेडिकल डॉक्यूमेंट यू आर नेक्स्ट
ନା ଆସିନି ରିପୋର୍ଟ ଲେଟର ଅଲରେଡି ସେଣ୍ଡ ମ୍ୟାଡମ ଲେଟର ଯାଇଛି ତ ଆସିନି କେତେ ମୋ ଚିଠି ଆସିଛି ଆସିନି ଆଜ୍ଞା
ଏଇଟା ଏଇଟା ତ 3 ଦିନ କିଆ ଲିଷ୍ଟ ପାଇଁ ଅଛି
ଆଜ୍ଞା
ଓ
କାଲିକି ଥାଉ
କାଲିକି ରଖ ଦଉଛି ଏଟା କାଲି ଡାକିବ କାଲି ମାନେ ଆମର ହେଲା 10 ତାରିଖ ମ୍ୟାମ କାଲି ହଉଛି କେତେ ତାରିଖ 13 ତାରିଖ 13 10 ରେ ଏଟା ଡାକିବ ଟିକେ ନୋଟ କରି ଦିଅନ୍ତୁ ଲିଷ୍ଟ ରେ କଜ ଲିଷ୍ଟ ରେ 10 ନମ୍ବର ଟା କାଲିକି ଡାକିବେ ହଁ 11 आगू करंतु आप
थैंक यू
My lord, here I am in custody, my lord, since 31/7/2020 under section 20B Roman 2C 25 and 29 of the NDPS Act. My lord, twice my bail was rejected. Firstly on 30th of March 2022, wherein the trial was directed to be expedited within a period of 4 months. And then again it was rejected on 16/3/23 with a further direction to dispose of within 2 months. Till date, my lord, no evidence has started.
स्टेटस रिपोर्ट मंगाई तला
No, status report happened.
Now you are a man from state of Bihar.
Yes, ma'am.
तो एड्रेस वेरिफिकेशन टा करेई दियंतु हम स्टेटस रिपोर्ट टा मगई दउची हां लेखंड द लर्निंग काउंसिल फॉर द सेल लास्ट ऑर्डर टा अछि कि आपन करो
आगे
जो बीएलएपीएल 7745 ऑफ 2022 रो ऑर्डर टा
पेज 25 रे मो एनेक्स
25 रे The London Council for the petitioner submitted that this is the third successive bail application of the petitioner. And the petitioner is in judicial custody since 31/7/2020. 2020. And last time when the petitioner approached this court for bail in BLAPL number 7745 of 2022, the same was disposed of as per order dated 16/3/2022.
23, man.
2023, directing the London trial court to conclude the trial within a period of 2 months. However, he has received instruction that not a single witness has been examined.
Till now, the telephonic instruction bill.
He has received instruction that no witness has been examined. Status report be called for. Then London Council for the State submits that the petitioner is a man from Aurangabad district in the state of Bihar, and he may be given some time to obtain instruction as to whether the address furnished by the petitioner in the cause title is correct one or not. Let the Superintendent of Police, Gajapati, make necessary communication with the Superintendent of Police, Aurangabad, in that respect. Matter to be listed in the week commencing from 30th of October 2023. The Learning Council for the state shall obtain the instruction regarding address verification in the meantime. Copy of the order be communicated to the Plan and Trial Court by registered judicial through email for obtaining the status report.
My lord, I'm sorry, my lord, I have to say. My lord, my friend says that one or two witness has been examined.
Acha, one or two witness, no witness jagar, one or two witness has been examined. 30 तारीख रखा है 38th of
ଟିକେ ଅଧିକା ଟାଇମ ଭେରିଫିକେସନ ଟା କରିବାକୁ ବି
अच्छा 6 नवंबर रखते 6/11/2023 address verification and status report.
My lord.
12 टा दिन आगु कौन माइक ऑफ हो जाएगी ऑफ ही जाएगी हाँ ऑन करो
Present petition is in custody, my lord. 21/3/2020, my lord. Lord, offense under section 20B 2C NDPS Act, my lord. So far as the present petition and one of the co-accused is concerned, 22 kg 600 grams. One of the co-accused also granted bail by this.
Your bail application was rejected in 2021. So what is the status of the case?
Lord, status, with my lord's permission, I have obtained certified copy of status report, my lord.
You have annexed some
copy of a deposition also, and also co-accused, all the co-accused bail order also.
No, ବର୍ତ୍ତମାନ case ର position କଣ?
Position, my lord, out of 25, only 9 witness has been examined. Last time also, third application, my lord, your lordship was pleased to grant 3 months interim bail. That time 8 witness has been examined. That is 2022, my lord.
କେବେ ଆପଣଙ୍କର interim bail ଯାଇଥିଲେ?
BLPL number 4258 of 2022, that is 22/11/2022
ସେ order ଦେଇଛନ୍ତି? ଯୋଉଟା ମୁଁ ଦେଇଥିଲି 3 ମାସ କେବେ BLPL
number my lord 4258 4258/2022 disposed of on my lord 22/11/2022 3 months, my lord. Timely he has surrendered and move up another bail application further.
ଆପଣ ଯୋଉ deposition copy ଦେଇଛନ୍ତି page 78 ରୁ ଜଣା ପଡୁଛି PW last witness ବୋଧେ PW 9 ନା କଣ 9 examined ହେଇଛି on 17th May 23. ତାପରେ ଆଉ କଣ ହେଇଛି?
ଆଉ କିଛି ହେଇ ନାହିଁ. certified copy I have obtained certified copy of status report.
Order sheet ର?
Yes, your lordship.
ସେ ଯୋଉ ବାହାର କଲେ ଏଇଟା ଏ କପି ନାହିଁ ଆପଣଙ୍କ ପାଖରେ
upload ହେଇ ନାହିଁ.
ଅପଲୋଡ ହେଇନି ଦେଖିଲେ 4258 କଣ ପାଇଁ ଅପଲୋଡ ହେଇଛି ମୋ ଅର୍ଡର ଥିଲା BLPL 4258 which is 2022. लिंगराज मेहर
ଦୁଇ 11 ଅର୍ଡର ଟା ଶୋ କରୁଛି ଇନଷ୍ଟ୍ରକ୍ସନ ପାଇଁ ରହିଥିଲା ସବସିକ୍ୱେଣ୍ଟ 22/11 ଅର୍ଡର ଟା ଶୋ 85 ଯୋଉଥିରେ 3 months
3 ମାସ ପାଇଁ ଯାଇଥିଲା
ଆଜ୍ଞା 22/11
Yes, Mr. Miller. Are the Learned Counsel for the petitioner, Learned Counsel for the state, Learned Counsel for the petitioner submitted that the petitioner is in judicial custody since 21/3/2020. And he was
21/3 your lordship 21/3
21/3 to 21/3/2020. And when he approached this court last time for bail in BLAPR number 4258 of 2022, है ना? He had order dated 22/11/2022. He was directed to be released on bail for a period of 3 months, interim bail, है ना? And after availing the same, he surrendered at right time. The Learned Counsel submits that till date, only 9 witnesses have been examined. Out of kete?
25
Out of 25 witnesses. And the last witness, that is PW9, was examined on 17th May 2023. And thereafter, no further witness has been examined. He files the copy of the order sheet of the Learned Trial Court, certified copy of the order sheet of the Learned Trial Court, which is taken on record. He further submits that in view of the delayed disposal of the trial, the petitioner may be granted interim bail for some further period. State Counsel has no serious objection, considering the submission, period of detention in the judicial custody, slow progress of the trial, conduct of the petitioner in complying with the earlier interim bail order. I am inclined to release the petitioner interim bail for a period of 3 months. Disposed of.
Lot 353 and 354. Record has come with 141.
Milord, Lordship, I'm through. Milord, I'm through hybrid mode in the matter 353 and 354. Lordship, in this matter, the address verification, the security verification, and the antecedents verification has been done, Lordship. And they are in JC from last more than 3 years, Lordship. And three other accused are already in bail, Lordship. 353 and 354.
Yes, just a minute.
Lord.
So these two cases are of the arises out of same case.
Yes,
yes, my lord. Yes, my lord.
Okay. So what is the date when these petitioners were taken into judicial custody?
Lordship, it was in the month of August 2020.
You have never been released on interim bail?
No, my lord. No, my lord. I am in jail continuous.
So, what verification you have made?
In both the cases.
So the address are correct.
Yes.
And also the bailers are genuine
genuine.
bailers. Both the cases arises out of same case.
Nandapur PS case number.
But a common order for them. Chalo. The hard Mr. Sam Manohar, Land Counsel, to virtual mode, Mr. Priyavata Tripathi, Land and Additional Standing Counsel. Mr. Manohar submit that the petitioners are in judicial custody since August 2020. And what is the progress of the trial?
Lordship, out of 20 witnesses, 4 or 5 has been examined as per my instruction, Lordship.
Out of 20 charge sheet witnesses, 4 to 5 witnesses have been examined. And in view of the delayed disposal of the trial, the bail application of the petitioner may be favorably considered. The Land and Counsel for the state was asked to make the address verification as mentioned in the cause title of the bail applications. So also to verify the genuineness of the bailers' local sureties whose names were furnished by the Land and Counsel for the petitioner. So also there the documents of the 2 local sureties. The Land and Counsel for the state has produced the written instruction received from Superintendent of Koraput, which dated 6/10/2023, which indicates that the address furnished in the cause title of the bail application are correct. Similarly, the bailers, namely Pitambar Turuk and Ruko Dhara Harijan. Harijan na कौन लिखा है? Harijan तो?
Yes.
हाँ Harijan. Are local sureties and their property details have also been verified. The written instruction received from the IAC Nandapur Police Station dated 25/9/2023 are also taken on record. Considering the submission made by the Land Counsel for the respective party, the period of detention of the petitioner in judicial custody, the slow progress of the trial. Acha, peruse the status report furnished by the Land Trial Court dated 12/9/2023, from which it appears that only 4 witnesses have been examined out of 13 charge sheet witnesses. जो 4 to 5 करना ना, से 4 कर दिया, है ना? Considering the submission, period of detention of the petitioner in judicial custody, slow progress of the trial, while not inclined to swan on merit, I am inclined to release the petitioner in view of the commercial quantity of ganja seized from the petitioner, and bar under section 37 of the NDPS Act. While not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody and slow progress of the trial, I am inclined to release them on interim bail for a period of 3 months. So State Council ko objection ne madhya eta lekhibe that commercial quantity of ganja bar under section 37. So 3 months bail granted. Disposed of.
I'm deeply obliged, Lordship. Lordship, seeking pardon. Lordship, seeking pardon. Just one more matter was fixed for today. Item number 7. Lordship, his wife's condition is not well.
Dispose of all the 3 months.
Disposed of. Yes. Item number 7.
Yes, Lordship. He is a local person, and in this same case,
just a minute.
Deepak Bairagi.
Please wait.
My lord.
Item number 7 is BLAPL number 7212 of 23.
Yes, Lordship. It's Deepak Bairagi.
No, that is perhaps your number is item number 6. That is 7166 of 2023. Deepak alias Deepak Bairagi, right?
Bairagi. Yes, Lordship. Yes,
So you have filed an application for interim bail.
Yes, Lordship. I have filed since the condition of wife is not well. She is suffering from serious heart issue, and Lordship, more than 3 years he is in jail. And in this case, last week 4 accused has been released on bail by my lord only on interim bail. More than 3 years of judicial custody, 26 kg of contraband has been allegedly seized. One home guard was allegedly attacked by 100 persons, Lordship. There is no specific allegation against me or any person. So, on the basis of vague and bald allegation, 100 persons has been falsely implicated, Lordship. So, just praying for interim release, at least for 3 months, my lord. He is a local person. There is no chance of absconding, Lordship.
No. What is the progress of the trial?
Lordship, out of 65 charge sheeted witnesses, only 9 has been examined.
65, 9 have been examined. And
yes, Lordship.
You are in custody since when?
Since August 2020. 3 years.
All right. Let me call for that status report. We'll
Lordship.
consider it.
Lordship, I'm obliged.
The item number 6, BLAPL number 7166 of 2023, heard Mr. Shyam Manohar, Land Council, virtual mode. He submits that the petitioner, Deepak alias Deepak Bairagi, is in judicial custody since August 2020. And out of 65 charge sheet witnesses, only 9 witnesses have been examined so far. And let a status report be called for from the London Trial Court. Matter be listed on such and such date. All items.
I'm deeply obliged.
Item 61. I am in VC. If your lordship will permit me through VC, my lord.
Yes. Just a minute.
Item 15, my lord. 15. Interim bail. Kindly see updated 4-8.
Put a 15 ta jo Kali mane dala ajio shi 12 13 tarik 13 10. Okay.
Obliged.
Okay. 141 I associate.
May I have given list जो फाइल आसी है जी से रखी देवे
हाँ यदि थिपे काउंसिल की इच्छा हो
ऑप्शन पर
हाँ
से सीरियल
रखी दो ना दी
बड़ा आई में पैडन 242
ताकू नंबर दियो मोर
नहीं ऑर्डर है सर लानी डिपोजिशन कॉपी जो दवा में कहउतिले आई ऑलरेडी अनेक्स्ट
अच्छा हाउ ठीक है
अनेक्स्ट 3 सीरीज शोर
हाउ से जो जे नंबर देइचंदी स्टेट काउंसिल से जे डाकी दियो हाँ से जे अपन डाकोंतु काउंसिल थिबे नियाव
69 violence.
Item number 86.
पट्टा दियंतु से फाइल टा आनिबे तापर मु नेबे
Can I make a mention, my lord? Item 61.
Item number 35.
मिस्टर महांती आपण नंबर टा स्टेट काउंसिल को दे दियंतु से फाइल टा मगेई देबे तापरे आसिला परे मु नेबी से आपण नंबर केते
Item 61, my lord.
61 टा मगेई देले आसिले मु डका जीवो हला आपण अपेक्षा करन
Item number 35.
Phone number केते आइटम नंबर
35 में
Yes, Mr. Roy, it is your matter.
My lord.
69. हाँ आर्गू करन दो
My lord, it's a case under section 140.
First application or earlier rejected?
First, my lord.
Okay. So, how many petitioners are there?
Only one.
What is the date of custody?
Custody, my lord, surrendered on 3rd February 23.
Charge sheet helani?
Charge sheet, my lord, 140.
absconder ପରେ surrender କରିଛନ୍ତି
Absconder पर surrender କରିଛି।
11 ର କେସ୍ 23 ରେ surrender କରିଛନ୍ତି
କେବେକା କେସ୍?
2012, my lord.
2012 case. Only one thing is that he is not named
Not
in the
named
FIR.
in FIR. Subsequently, my lord, those persons who are arrested, they have taken my name.
But however, just 2023 she has surrendered.
କୋଉଠି ଲୋକ କୋଉଠି?
ଏଇ ଓଡ଼ିଶୀ ଆସ୍କା side.
କୁଆଡେ ଯାଇଥିଲେ କୁଆଡେ?
My lord, I have no knowledge regarding this, my lord. The co-accused person have been implicated me.
You have not been named in the FIR?
No, my lord.
What are the offences under which charge sheet submitted?
Offences, my lord, 147, 148, 302, 307, 506, 149.
What is the name of the deceased?
Bansi.
Eyewitnesses must be there because
My lord,
307 is there.
the informant himself is the eyewitness.
Informant ନା କଣ ତାର? Informant ହେଲା ରମା ଗୌଡ଼।
Specifically
ସେ ପରା 14 ଜଣଙ୍କ ନାଁ କହିଛି। ଆପଣ ନାଁ
ନାହିଁ subsequently
କେମିତି ଆସିଲା ନା କେମିତି ଆଇଲା?
co-accused statement ଆସିଛି।
ଆଉ ସେ ଯୋଉ accused ଗୁଡାକ ସବୁ
other accused have been granted bail, my lord.
Some of them have been bail.
Trial ହେଇନି ସେମାନଙ୍କ
trial
ସେମାନେ bail order
ଯୋଉମାନେ ଯାଇଛନ୍ତି ସେମାନେ ସେଇ footing ରେ ଅଛନ୍ତି ନା ଖାଲି I have to take that instruction, my lord.
ନାଇଁ ଆପଣ ଯୋଉ bail order କିଛି ଅଛି ଦେଇଛନ୍ତି?
ନା ଦେଇନାହାନ୍ତି ସେଇଟା।
ଯୋଉ 8345 ଯୋଉ ଗୋଟା ଦେଇଛନ୍ତି?
Kindly have a glance page 17 to 26, my lord. I have given some bail orders.
17 to 26?
Yes.
ଆଚ୍ଛା ନଙ୍କା ଗୌଡ଼ ଗୋଟେ କଣ ଯାଇଛି?
They have assaulted. They are named in FIR and assaulted.
Oh, named in the FIR and assaulted.
Yes.
ଆଚ୍ଛା। ମିସେସ୍ ପଟ୍ଟନାୟକ ଏଇ ଯୋଉ ଗୁଡାକ ଦେଇଛନ୍ତି 17 ରୁ 26 କହୁଛନ୍ତି ଏମାନଙ୍କ ନାଁ ଗୁଡାକ FIR ରେ ଅଛି ଆଜି ଆସିଲାଣି ବୋଲି?
ମୋର ଫର୍ଷ୍ଟ ଟାଇମ ଅଛି ଆଉ ଗୋଟେ ନେକ୍ସଟ ୱିକ୍ କୁ ଆସୁ ମାଇଲର ମୁଁ ଟିକେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବି।
ନାଇଁ
ହଁ ଅଛନ୍ତି ସେଇଥିରେ ସେମାନେ ଅଛନ୍ତି ରାମ ଗୌଡ଼।
ନାଇଁ ଗୋଟେ ଦିଟା ନାଁ ଦେଖି ଦିଅନ୍ତୁ।
ଆଜ୍ଞା ଦେବରାଜ ଗୌଡ଼ ସନ୍ତୋଷ ଗୌଡ଼
FIR ରେ ଅଛି ତ?
ଦେବରାଜର ନାଁ ଅଛି ଆଜ୍ଞା।
FIR
ସନ୍ତୋଷ ଗୌଡ଼ ବି ନାଁ ଅଛି।
ଆ ନାଁରେ ମେନ୍ ହଉଛି ସେଇ absconding ଟା ରହୁଛି ଆଉ କଣ?
ସେ absconding after almost 10 years।
ଏ ଲୋକ ଲୋକାଲ
ଆଜ୍ଞା
କଣ ଏତେ କଟାକଟି କରୁଛନ୍ତି ଆଉ ସେ
filed my lord amended cost title, my lord, that is there also.
ଆଚ୍ଛା ହଉ। Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner voluntarily surrendered in the court on 3/2/2023, and since then he is in judicial custody. He has not been named in the FIR, though it was lodged by an eyewitness to the occurrence. And charge sheet has already been submitted under section 147, 148, 302, 307, 506, 149 of the Indian Penal Code. Some of the co-accused persons named in the FIR as the assailant of the deceased Bansi have also been released on bail. And the petitioner implication is mainly based on the confessional statement of co-accused, and therefore the bail application may be favorably considered. Learned counsel for the state has, after going through the bail orders annexed to the bail application, has annexure 3 series, and the FIR lodged by the injured eyewitness fairly submits that the petitioner has not been named in the FIR and co-accused persons who have been released on bail, some of the co-accused persons released on bail are named in the FIR as the assailants of the deceased. However, she opposed the prayer for bail mainly on the ground that the petitioner was an absconder. It's a case of the year 2012 when the petitioner was an absconder.
मतलब का चार्जशीट डेट टा रही जाओ 10/11/2012
And the occurrence took place. The FIR was lodged
12/10/2012
12/7/2012 FIR was lodged. Charge sheet was submitted on
10/11/2012
10/11/2012 showing the petitioner as an absconder.
abscond.
The London Council for this petitioner, on the other hand, submitted that the petitioner was not aware about the pendency of the case. Considering the submission, nature of accusation against the petitioner, period of detention of the petitioner in judicial custody, release of the co-accused persons on bail, and since the petitioner is a local man, I am inclined to release the petitioner on bail subject to condition that he shall appear before the London trial court on each date when the case would be posted for trial and shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail allowed.
I may permit to correct the title. NAIK NAYK I have done. See, NAYK NAIK.
Land Council for the petitioner seeks permission to correct. Eta kette thara correction kaleni apan. Permission to correct the cause title in the surname of the petitioner. Permission is granted. Ajira au gote date pakeibe. Yeah.
27.
Item number 27.
Lord, petitioner is custody since 25/12/2019. Lord. One of the co-accused person.
Argu karan.
Lord, custody since 25/12/2019. Lord.
25/12.
2019. Lord. And one of the co-accused person, namely Sekhar Unna Bindhani, granted bail. Lord. And so far this petitioner is concerned, 2 times he has granted interim bail and surrender in time. Lord.
Kebe last kebe jaitile?
Last order I have not available, but the previous order I have.
Last number ta kete kuhundu?
Taiseta mu net re bhi pailini madam.
Abana, okay, this bail application is item number 27.
Yes, Lord.
10,663 ଆପଣ ଆଗରୁ ଆସିଥିଲେ 2455/2021 ଗୋଟେ ଆସିଥିଲା ସେଟା କଣ ହେଇଥିଲା?
This is the order, my lord.
ଏଟା 3 ମାସ ଆପଣ ବେଲ୍ ଦିଆ ହେଇଥିଲା?
Yes, my lord. ତାପରେ ବି ଆଉଥରେ 3 ମାସ ଯାଇଥିଲା।
ତାପରେ ଆଉ କାହିଁ?
ତାପରେ ଯାଏ ଗୋଟେ ଜଣା ପଡୁନି my lord, but
ଆଉ ତ
in 4617 of 2020 my lord, ସେଟା ଆଗରୁ
46?
No, that is not my lord.
ଆପଣଙ୍କର ଅଫିସିଆଲ ଇଏ ଦେଖଉଛି ଯେ ଆପଣ ଗୋଟିଏ ଥର ଆସିଛନ୍ତି ଏବଂ ସେଥିରେ ସେ ଅର୍ଡରଟା ଆପଣ ଦେଲେ।
ଆଜ୍ଞା। ଆଉ ଟୁନା ବିନ୍ଧାଣି ମିଲଟ ଗ୍ରାଣ୍ଟେଡ ବେଲ୍ ମିଲଟ ଆଇ
ସେ
ହାଭ୍
ଛାଡନ୍ତୁ,
ଅଲସୋ
ଇଏ ଲୋକ ଯାଇଥିଲା 3 ମାସ ପାଇଁ। ବର୍ତ୍ତମାନ କେସ୍ ର ପୋଜିସନ କଣ?
ଟ୍ରାଏଲ ଇଜ ଗୋଇଂ ଅନ୍ ମିଲଟ।
ସରେଣ୍ଡର ଠିକ ସମୟରେ କଲେ?
Yes, yes, मिलट।
कौन कहुचंदी मिस्टर?
Yes, मिलट।
Heard the London Council for the petition and Council for the state. The London Council for the petitioner submitted that the petitioner was taken into judicial custody on 25/12/2019, and when he approached this court last time for bail in BLAPL number 2455 of 2021, by the order dated 25/2022, he was granted interim bail for a period of 3 months, and after availing the same, he surrendered at right time. And till date, there is no such the trial is going on, and since the petitioner has not flouted the terms and condition of the earlier interim bail order, the bail application may be favorably considered. And counsel has also filed the bail order of one Tuna Bindhani, which is taken on record. Land counsel for the state has no serious objection to the grant of interim bail. Considering the submission, period of detention of the petitioner in judicial custody, conduct of the petitioner in complying with the earlier interim bail order, in view of the commercial quantity of ganja and bar under section 37 of the NDPS, we are not inclining to release on merit, 3 months bail is granted. Yes, disposed of.
Item number 14.
Item number 29.
14. କେତେ ଡାକିଲେ?
14, sir.
14.
Sir, kindly grant the passover.
କଣ ଏଇଟା 14ଟା କଣ ଦେଖିଲେ? ଆସନ୍ତୁ ଆଗକୁ ଆସନ୍ତୁ. What is your name?
Kamalakant Sethi.
Huh?
Kamalakant Sethi.
କମଳାକାନ୍ତ
Sethi.
କଣ ହେଇଛି କୁହନ୍ତୁ କଣ?
My senior is not available.
ଆପଣ କରନ୍ତୁ, ମେନସନ କାଇଁ କରୁଥିଲେ? ଏଟା ମେନସନ କଣ କରାଇଲେ କଲା ପରା?
After lunch.
ମିଷ୍ଟର ମାଇଲର, ଏଟା ମେନସନ କରିଥିଲେ?
ଏବେ କହୁଛନ୍ତି ସିରିୟଲ ନବା ପାଇଁ ଯୋଉଟା ଅଛି ଫାଇଲ ଅଛି।
ନାଇଁ ସିଏ କହୁଛନ୍ତି ଆଡଜର୍ନମେଣ୍ଟ ମାଗୁଛନ୍ତି।
ନାଇଁ
passover.
ପାସଓଭର ମାଗୁଛନ୍ତି। ପାସଓଭର ଦିଆଯାଉନି। କରନ୍ତୁ ମ୍ୟାଟର କଣ କରିବାର। କଣ ହେଇଛି କୁହନ୍ତୁ?
Let's say my senior is not available.
NDPS ମାଇଲର କମର୍ସିଆଲ କ୍ୱାଣ୍ଟିଟି ବ୍ରାଉନ ସୁଗର 2020 ଆଗକୁ ଆସିଥିଲା।
ଆଗରୁ ଆସିଥିଲେ? କେବେଠୁ ରହିଲାଣି?
ଆଗରୁ ଗୋଟେ
8/11/20। ହୁଁ 8/11/20 ପାରାଗ୍ରାଫ 9 ରେ ଲେଖା ହେଇଛି। ବ୍ରାଉନ ସୁଗର ଅଛି କମର୍ସିଆଲ କ୍ୱାଣ୍ଟିଟି 257 ଗ୍ରାମ। ହଁ ଇଏ केस डायरी पड़े आसी तो
आगे
आउ कोन क्रिमिनल एंटीसीडेंट अछि
एंटीजर के रिफ्लेक्ट करने बर्तमान
देखो कोन लोक कोडी यार
पुरी रो कोट्टे मिनट रमीन मलिक रम मतलब another 4 cases are there
4
मतलब
को केस सब
एनडीपीएस भी अच्छी है
हां ताले कॉमर्स ये फाइल करूं तो से कॉम्प्रिहेंसिव एफिडेविट यारी नार अछि तो
हाँ रमणी
मल्लिकाना
involved in following cases 4 cases मतलब
चारटा केस एनडीपीएस चारटा को
चारटा करो दीटा होची एनडीपीएस गोटे होची एक्साइज ने कोन आ गोटे 307
अच्छा लेखन
दीटा 307 एक्साइज नहीं सॉरी yes sir
दीटा एनडीपीएस
दीटा 307
please all right the this is item number 14 okay the BLAPL number 7480 of 23 the Land and Council for the state on verification of the case diary submits that the petitioner एक को मिसे कि नहीं चार ही
नहीं
ना
एटा
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 छाड़
304 नहीं आपको छाड़ी की चारटा
अच्छा the petitioner has got 4 criminal antecedents and 2 of them are under NDPS Act and 2 of them are under 307 IPC na
दीटा
okay let the Land and Council for the petitioner obtain instruction about such criminal antecedent and file a comprehensive affidavit relating to the status of such cases. Put up this matter in the week commencing from 30th of October 2023. कौन बुझिले कौन मु ऑर्डर कली कौन ऑर्डर कली और आ सीनियर पचारिबे कौन आज ऑर्डर हैला अपन जाइथिले कोर्ट कौन कौन कहबे अरे कौन कहबे कहउनाती केते मास हलानी प्रैक्टिस हला
10 days. 10 days.
10 days कहबे स्टेट काउंसिल कहले आनार आउ चारटा केस अछि आउ दीटा एनडीपीएस एक्ट रो आउ दीटा 307 आईपीसी रो 307 आईपीसी कोन जानचंदी कोन
Punishment for murder.
हां
Punishment for murder.
पनिशमेंट फॉर मर्डर आज घरे पड़िबे 307 कोन हला तो से जो चारटा केस रो वर्तमान आपन को स्टेटस कोन बेल ले जाइछंती कि नाही ताकू सेउडा को सब लेखिन गोटे कॉम्प्रिहेंसिव एफिडेविट देबे हला देला परे 30 तारिख दिन सुनानी हबो बुझ परले जान कोन ना कोन कमलाकांत
सेठी
ना ना लिख दियो हार्ड मिस्टर कमलाकांत सेठी जान
Item number 29.
My lord, item number 29.
Hmm.
My lord, offense under section 302, 201 and 34 of IPC.
Just a minute. 29 na
Aye.
Are there case diary achi
Yes, Miller.
all right what is the date of custody
My lord, 19/12/2020.
charge sheet कोत रही छी
Charge sheet on date 17/4/2021.
charge sheet को offense रही छी ना 17
302, 201 and 34 of IPC.
302 201
And 34 of IPC.
what is the name of the deceased
CORAM Kana.
Coran KARAN
KARAM.
तापरे
KANA.
जन्ना
Konna.
KAN date of occurrence
18/12/20
eyewitness अछंती
Yes, sir.
ना कोन कोन तो गोटे
One of the informant, Srimati Kormar Rame.
कर्मा
हाँ Korama Rame.
Ramaiya.
Rame khali.
R-A-M-E.
M-E.
R-A-M-E. See how she is related to the.
She is the wife of the deceased.
Okay. कौन कहिछि से?
Yes, I am reading that. ମୁଁ ଆଜି 19/12/20 ତାରିଖ ଦିନ ମୌଖିକ ବୟାନ ଦଉଛି ଯେ ଗତକାଲି ରାତି ପ୍ରାୟ 9ଟା ସମୟରେ ମୁଁ ଏବଂ ମୋର ସ୍ୱାମୀ ଆମ ଘରେ ଶୋଇଥିବା ସମୟରେ ଆମ ଗାଁର ବେଟି ଦେବା ପିଟିସନର ପଦିଆ ଏମେଲା ପଦିଆ ବାଡସି ଗଙ୍ଗା ବେଟି ଏବଂ ସୋଡି ସୁକାଶ ଗୁଣି ଗାରିଡି ସନ୍ଦେହରେ ଲୁହା କାତି ଓ ଠେଙ୍ଗା ସାହାଯ୍ୟରେ ମୋ ସ୍ୱାମୀକୁ ହାଣି ମାରି ଗଣ୍ଡିରୁ ମୁଣ୍ଡ ଅଲଗା କରିଦେଲେ ଏବଂ ମତେ ମାରିବା ପାଇଁ ଧମକ ଦେଲେ, ଯାହା ଫଳରେ ମୁଁ ଭୟରେ ଘରୁ ପଳେଇଲି। ଏମାନେ ସମସ୍ତେ ମିଶି ମୋ ସ୍ୱାମୀକୁ ଜୀବନରେ ମାରି କୁଆଡେ ଫିଙ୍ଗିଦେଲେ।
My lord,
she is an eyewitness.
Trial has commenced, and my lord, the informant has turned hostile. I have annexed that in Annex 3, your lordship. A total of 8 witnesses has been examined, and all the 8 witnesses have turned hostile.
से जो informant है ये
Again,
PW
PW4, your lordship. Sorry, your lordship. PW2, your lordship. Page number 23 of my petition.
PW2.
Again.
Budrai Emla. PW2.
हाँ सेही कहूची तो I am the informant कहूची किंतु
I am the informant. I
भूले कहू कौन है तुम जाननी किंतु ये the statement of the complainant Srimati Karma Rame.
Karma
Rame, the wife of the deceased.
से किंतु से कहूची रुहंतु FIR टा देखिवा कर्मा रामा हाँ ठीक कर्मा रामा
She is not the wife of that.
हाँ नहीं ठीक you are right कर्मा रामे ये जो ये लोकडी एग्जामिन ହେଇची कि जो कर्मा रामे जी है because she is the widow of the deceased and she happens to be the eyewitness to the occurrence. So आपण जो साक्षी मानकर जमानबंदी देइचंदी ता दूर जणा पडुनी से
कर्मा रामे है ना
किंतु ये लोकडा जो कहिला कोन एमती
सेटा I know the informant जगह I am the informant.
हां सेया है
टाइपोग्राफी लागू
अच्छा गोटे काम करंतु आपण से इन्फॉर्मेंट को प्रोड्यूस करंतु नेक्स्ट डेट केबे अछि ट्रायल लो
I need to take instruction, your lordship.
हां ओवन फोन ले जानतु से सही साकीटा हेई जो आपण बेल विचार करिया लेखन the learned counsel for the petitioner submitted that till now in the trial court 8 witnesses have been examined and none of them has stated anything against the petitioner. The learned counsel for the state, on the other hand, submitted that the informant, Srimati Karam Rame, K-A-R-A-M hela Karam, Rame hela R-A-M-E, is the widow of the deceased, Karam Kana, and she is an eyewitness to the occurrence and she has not been examined. Either eight is done. तो एटारे सत्यनारायण मिश्र को अच्छा आपण फाइल कर दीजिए এটা कितना नंबर केसटा ये 29 all right you will be engaged there is no problem in that so let the inspector in charge of Odia police station appear before the London Trial Court, that is Additional Session Judge Malkangiri, in city case number 88 of 2021, on or before the last day, 19th of October 2023, received summons in respect of the informant
and other eyewitness
and other eyewitnesses, if any, available on record. Bracket रे लिखी दियंतु. The records, the trial court record is to be verified by the public prosecutor and submit the list, bracket ends, and ensure their attendance on the date fixed. Matter to be listed in the week commencing from 6th November 2023. If the informant and other eyewitnesses, if any, are examined, the London Counsel for the petitioner shall produce the certified copy of their deposition on the next day, giving copy to the London Counsel for the state. Free copy of the order be handed over to the London Counsel for the state. Sabha upar lekhi debe. Received the prisoner's petition, in which the petitioners have prayed for engagement of Mr. Satyanarayan Mishra as their advocate. Mr. Mishra has also filed wakalatnama for the petitioners, which is taken on record. The name of Mr. Satyanarayan Mishra shall be reflected in the cause list. The names of Mr. Pushpamitra Mahapatra and his associates shall not be reflected in the cause list henceforth. तापरे से order to कर दे.
Item number 26.
Well, I am submitting on behalf of Adhikari Dityanandan Das Miller. Well, in this case, Miller, present petitioner was on interim bail, and subsequently thereafter he has surrendered. He is in custody since 10/8/20.
ଏଠାରେ ଆପଣ interim bail ଯାଇଥିଲେ?
ଆଜ୍ଞା।
କେତେ ମାସ ପାଇଁ?
6 ମାସ ପାଇଁ ଯାଇଥିଲେ, ତା ମାର ଦେହ ଖରାପ ଥିଲା।
6 ମାସ ପାଇଁ ଯାଇଥିଲେ?
ଆଜ୍ଞା। ମାଇଲର ଜଷ୍ଟିସ
କେବେ surrender କଲେ?
I have filed the surrender certificate already.
No, what is the when you were granted bail and when you surrendered?
Like bail granted on 21/12/2022. 21/12.
BLAPL number कितने?
In BL this BL number 7903.
वो
IA number in
ଯାଇଥିଲେ 6 ମାସ?
In IA number 2272 of 2020.
Wait.
And Justice V. Narsim granted.
You are granted interim bail for 6 weeks.
Mallet.
Then extended
Thereafter is surrender.
Acha, it was extended. Then extended till 24/2/2023. तापर अपन surrender करी गले?
आगे.
Where is the surrender certificate?
Already filed.
3/4/23 ରେ ଫାଇଲ କରିଥିଲେ।
तो इनिशियली आपण केबे कस्टडी गले?
कस्टडी गले 10/8/2020
10/8/2020
आगे।
So what is the status of the trial?
Status as per instruction miller, some seizure witness has been examined.
Status report मगा ही नथिला?
My lord,
Status report मगा ही नथिला? आपण बारे ऑर्डर शीट किछि अछि?
order sheet ଅଛି ଆଜ୍ଞା।
स्टाटस रिपोर्ट आसी जाओ देखी केबे कार ऑर्डर शीट
जुलाई पर्यंत अछि तापर मु इंस्ट्रक्शन परे मागिथिली से कहले सम सीजर विटनेस has been examined।
नो इटा तो आपण देइचंदी PW5 होची लास्ट विटनेस
ना इटा पीडब्ल्यू को डाकी थिले किंतु केही एग्जाम हेइ ना
हां
केही एग्जाम हेइ ना
आपण बा PW5 रो डिपोजिशन कॉपी देइचंदी इथु जणा पडुची PW5 एग्जामिन ऑन 25th August 2023 एटा ई केस ना आ को केस
एक केस रे
आ कहउचंदी नाही बिल PR number 12 of 2020 हां What is the total number of charge sheet witnesses?
total में
Have you got the copy of the charge sheet? Mr.
Yes, Mulad.
16 ଜଣ
16
ଏଠି ଆପଣଙ୍କର ଯୋଉଟା ଦେଇଛନ୍ତି 5ଟା ସାକ୍ଷୀ ହେଇଛନ୍ତି ଅଗଷ୍ଟ ପର୍ଯ୍ୟନ୍ତ 5ଟା ସାକ୍ଷୀ ହେଇଛନ୍ତି ଆପଣଙ୍କ କଷ୍ଟଡି ଡେଟ୍ ହଉଛି 10/8/20 ଏଟା ଠିକ ଅଛି 10/8/20 ମିଷ୍ଟର ଫାଇନାଲ ଫର୍ମ ଟା ଟିକେ ଦେଖିଦେଲେ ମିଷ୍ଟର ତ୍ରିପାଠୀ
ଦେଖିଦଉ 10/8/20 डेट ऑफ अरेस्ट
ଲୋକ କୋଉଠିକାର
ଲୋକ ହଉଛି
ହଉଛି
ରାୟଗଡା
local ଲୋକ
ଆଜ୍ଞା
all right heard the learned and counsel for the petitioner and counsel for the state ଆଉ କିଛି ନାହିଁ ତ criminal antecedent
ନା ଆକ୍ସିଡେଣ୍ଟ ନାହିଁ
learned counsel for the petitioner submit that the petitioner is in judicial custody since 10/8/2020 was taken into judicial custody on 10/8/2020 and till date he has received instruction that only 5 witnesses have been examined out of kete koile
16
out of 16 charge sheet witnesses learned counsel further submits that this court has been pleased to release the petitioner on interim bail as per order dated 2/2 as per order dated 21/12/2022 for a period of 6 weeks which was extended as per the order dated 2/2/2023 and after availing the interim bail period is surrender at right time and in view of the slow progress of the trial the bail application may be favorably considered. The learned counsel for the petitioner has filed the certified copy of the order sheet along with the deposition of witness which is taken on record. Learned counsel for the state opposed the prayer for bail mainly on the ground that the commercial quantity of ganja was seized from the vehicle in which the petitioner was present. considering the submission made by the land council for the respective parties. Quantity of ganja seized bar under section 37 of the NDPS Act. While not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody, so progress of the trial and conduct of the petitioner in complying with the earlier interim bail order of this court, I am inclined to release him on interim bail for a period of 3 months. The date of release is disposed of. This is item number 26.
Oblige.
Item number 22.
May
Oblige.
ହଁ ନାଇଁ ନାଇଁ ଯେ ଆଜି ଆସିବ ପଚାରିବା ପାଇଁ କାଲି ତ ରହିଥିବ ନା 2 PM ରେ ହଁ ଠିକ ଅଛି
Item number 31.
May I please, Your Lordship? The last occasion, Your Lordship is directed to release the petitioner on bail by furnishing the local securities, Lordship. And I have already obtained the
this
instruction.
is an outsider
My lord. Is in custody since last.
you have supplied the
My lord.
ଦେଇଛନ୍ତି affidavit with sureties ଆମର verification ପାଇଁ ଯାଇପାରିନି
ନାଇଁ address verification ହେଇଯାଇଛି
ନା
କିଛି
ଆଗରୁ
ହେଇନି
ହେଇଥିଲା
କିଛି ହେଇନି
ଆଗରୁ ହେଇଥିଲା
ନା ହେଇନି ତ ଆମର କିଛି
ଅର୍ଡର ସିଟ୍ ରେ ମେନସନ ହେଇଛି
ଆପଣ ଦିଆ ହେଇଛି affidavit ଦେଇଛନ୍ତି ଆମ ପାଖକୁ ଆସି
the address furnished by the
but
petitioner the cost
in
item.
a order dated 36/23
Yes.
it is mentioned that the land and council for the state furnish the instruction as per the orders of this court that there is no criminal antecedent
criminal
and
antecedent କଥା ଅଛି
and the address furnished by the petitioner in the cause title is a correct one that is the order dated 36/23 ତେଣୁ ଆପଣ କିଛି ପାଇଛନ୍ତି ବୋଧେ ପାଇକିନି କହିଲାଠୁ ମୁଁ ଲେଖିଲି ନା ତ ଆଡ୍ରେସ ଭେରିଫିକେସନ ହେଇଯାଇଛି ସେଇଥିପାଇଁ ତାଙ୍କୁ କୁହାହେଲା ଯେ
Security
ସିକ୍ୟୁରିଟି ଟା
verification ନାହିଁ
ନା ସିକ୍ୟୁରିଟି
address verification
ସିକ୍ୟୁରିଟି ଭେରିଫିକେସନ ପାଇଁ
ଟିକେ address verification ବି morning ନା address verification actually ଆସିନି antecedent ଆସିଛି ନା ଠିକ ଅଛି
ଆପଣ ପରା ସେଇଥିରେ ଯୋଉ
ମନ ପ୍ରୋବ୍ଲେମ can it pass over my lord because Mr. was doing just accent
କାରଣ ସେ ତା ଦେହରେ ଯୋଉଟା ଆସିଛି
ଆଜ୍ଞା
ସେ ଥାନାରୁ ଲେଖା ହେଇଛି
ଅଛି କି
ହିନ୍ଦୀରେ ଲେଖା ହେଇଛି ଆମକୁ ଦେଇଛନ୍ତି କପି
ଦେଇଛନ୍ତି ତାହେଲେ ଥିବ
ସେଇ ଯୋଉ ଉଲୁଣ୍ଡା ପୋଲିସ ଷ୍ଟେସନ ସୁବର୍ଣ୍ଣପୁରର
ଆଜ୍ଞା ତାହେଲେ ହେଇଥିବ
ସେଠି ଲେଖା ହେଇଛନ୍ତି ଅବଗତ କଣ करना है कि वीर प्रताप सिंह उर्फ विपिन कुमार पुत्र स्वांशो कोई भी मुकदमा पंजीकृत नहीं है रिपोर्ट सादर सेवा पे एटा अच्छी
सीडीटा टाइप करना तो
तो दीटा जिनस जहाँ जना पड़ी हेची गोटे होची एड्रेस वेरिफिकेशन आ गोटे होची क्रिमिनल एंटीसिडेंट ओनली ये जो सिक्योरिटी वेरिफिकेशन टा हवा दरकार नेक्स्ट वीक रखुची कर दियो को थाना एटा की
सुवर्णपुर
हां मगई दन ता पठेई दी थिबो त आगुरु पठेई जन ना
नहीं जाएगी
जाईनी न जाईतिला कोडो
Submit direct the code below to verify the.
ना ना ये लखन the Land and Council for the state seeks some further time to verify the genuineness of the sureties and the authenticity of the documents of those sureties to local sureties put up this matter after ensuing puja holidays ko eta ket number 31
28 man.
हाँ 28 टा कौन तो कौन
Item number 4.
May it please your lordship. The humble petitioner.
Yes.
The humble petitioner has been in judicial custody, my lord, for the last 5 years. He was taken to custody on 16/12/1918, my lord.
Earlier, your bail application was rejected.
My lord.
So, how many? This is the what is the number of this bail application? How many times you have approached this court?
I had approached once, which is rejected, my lord. Rejected on March of 2022, last year.
No, you have never been released on interim bail.
That was granted. I have not misalleged and surrendered, my lord.
No, after availing the interim bail period, you surrendered.
My lord.
So, last time when you approached this court, what is the BLAPL number?
My lord. 7617. 7617.
Please pass on the order. Let me see. 7617 of 2019.
Disposal upon 7/3/2022.
But thereafter, you seems to have approached once again.
Yes, my lord. Thereafter, some other person.
No. This Ganesh Patra.
Yes, my lord.
9325 of 2022.
My lord, but not pressed, my lord. He didn't press it, my lord. He didn't at all press. Some other lawyer was there.
No, it's all right. No. So this was rejected.
My lord, rejected.
And the other one, you said 9325 of 2022.
My lord, that was not pressed.
Just a minute. Have you got the copy of that order?
No, my lord. I haven't.
I've
seen that, my
Wait.
lord.
BLAPL 9325 2022. April 23. Order टा बाहर के लिए कौन है? 3rd April ता ऊपर
April 3rd April.
Not pressed. Okay. So now what is the date of custody? 16/12/2018.
My lord, almost 4 years, above 10 months.
What is the progress of the trial?
My lord, I'm submitting. 3 witnesses have been examined. There are nearly 27 witnesses. They were examined in July 2018. All have denied, my lord. That witness. Eyewitness.
Have you supplied deposition?
Yes, my lord.
Tinta chada olga other eyewitnesses are there, my lord. In the rejection order also 2 names are mentioned, that Upendra Parida and Rajesh Mohanty, witnesses against the present to petitioner, and also Kuni Padi is Sethi is also there.
ଠିକ ଅଛି
I'm
ବର୍ତ୍ତମାନ
stating, I'm
ଆପଣ
stating.
ଏଇଟା ହଉଛି ସେସନ୍ସ ଟ୍ରାଏଲ ଅଫ ଦି ଇୟର 2020 2020ର ସେସନ୍ସ ଟ୍ରାଏଲରେ ଆପଣ 2023 ମସିହା ପର୍ଯ୍ୟନ୍ତ ଯୋଉ ତିନିଟା ସାକ୍ଷୀ କରିଛନ୍ତି ସେ ତିନିଟା ଯାକ ସାକ୍ଷୀ ହୋଷ୍ଟାଇଲ ହେଇଛନ୍ତି ତେଣୁ ଆପଣ ଆଉ ସାକ୍ଷୀ ଅଛି ତାଙ୍କର 161 ଅଛି ସେମାନେ ସପୋର୍ଟ କରିବେ ନ କରିବେ ସେଥିପାଇଁ ଇଏ ରହିଲାଣି ପୁରା
4 ବର୍ଷ 10 ମାସ
4 ବର୍ଷ 10 ମାସ
11
ହେଇଗଲାଣି Heard the Land and Counsel for the petitioner and counsel for the state. The Land and Counsel for the petitioner submitted that when the petitioner approached this court first time in BLAPL number 7617 of 2019, same was rejected as per order dated 7/3/2022. And subsequently, the petitioner filed another bail application by BLAPL number 9325 of 2022. Which was disposed of as not raised. It is submitted that even though it's a sessions trial is of the year 2020, but only 3 witnesses who claim who are the eyewitnesses to the occurrence as per the charge sheet have been examined and none of them have supported the prosecution case, and therefore in view of the inordinate delay in disposal of the trial, the bail application of the petitioner may be favorably considered. Land counsel for the state on verification of the case record submits that there are other eyewitnesses to the occurrence who have not been examined. Considering the submission, nature of evidence adduced so far in the trial court, period of detention of the petitioner in judicial custody, and slow progress of the trial, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail allowed.
Item 61.
ये सीरियली जाउची तो जदि किए अछंदी
Item 13
आई रे डिस्पोज ऑफ कर आई गोटे कोन रखा है जेटा कोन एक्सटेंशन ऑफ इंटरिम बेल आपण सरेंडर करना थिले की
ନାଇଁ କରିଥିଲି ଆଉ ଥରେ କରିଥିଲୁ ନଟ୍ ପ୍ରେସ୍ ସେଇଟା
अच्छा आई एटा नॉट प्रेस कर दूं ऑलराइट
Item 13 मैडम
Item number 13.
13 13
13 मैडम may please your madam. Opposition 20B, 2C, 25, 27A, and 29 of NDPX Act, my lord. And in this case, my lord, other accused persons are already released on bail, my lord. Only my lord, confessional statement, the present prisoner.
No, it's a case of seizure of commercial quantity
Commercial
of ganja.
My lord.
So you are not found
No,
at
my
this spot.
No, my lord. My lord, custody since my lord 7/6/2023, my lord. Only my lord, confessional statement, kindly see my lord. Page number 9.
Page number 9.
My lord.
धरा पड़ले की माने डिटेन डिस्क्लोज देयर नेम as ना कोन
First, ये ना मैं दीपक वाला मैं.
दीपक बाला हाँ
My lord.
धरा पड़ले गोपाल रॉय विक्रम मंडल राजेश मंडल महानंद हालदार महानंद गलरेज सुखजीत सिंह अच्छा they further stated that one Krishna Vallabh so and so तो आपनो ना कोन एफआईआर नाही ना कोन
एफआईआर अछि my lord.
कोडी
One Deepak Bala and R Gopal were piloting them from Deepak Bala left from the motorcycle and fled away, taking the advantage of the darkness, my lord.
से जो कोआक्यू स्टेटमेंट रो असला
My lord.
yes Mr. आउ कोन क्रिमिनल एंटीसीडेंट किछ अछि की
सेटा ठीक
No,
आसीने
no, my lord. No criminal. As per my interest, my lord.
चार्ज शीट हेलानी
Yes, my lord.
I request
Charge sheet 2021.
एगुड़ा करे 6 मास समय ना चार्ज शीट फाइल करियारो 180 दिन ताकू से पुणी एक्सटेंशन हो परिवो जानिचंदी जदि कोहंतु न जानिचंदी जदि कोहंतु चार्जशीट हेची कि नहीं आपन प्रश्न पचारुछि
चार्जशीट my lord, I have
नो नॉलेज अछि
no knowledge.
हार्ड द लॉर्ड एंड
My
काउंसिल
lord, my lord. My lord, charge-sheeted my lord only 37/2021 my lord. 37 my lord.
चार्जशीट हेई जी
My lord.
पास ऑन करून सेटा चार्जशीट कॉपी
ये
टा
है 6/7/2023.
द लॉर्ड एंड काउंसिल फॉर द
ये चार्जशीट पर ही अरेस्ट हिच
हां
तने ओपन थी होते तापरे अरेस्ट हिच
the Lord and Counsel for the petitioner submitted that the petitioner was taken into judicial custody on 7/6/2023 and the implication of the petitioner is based on the confessional statement of co-accused persons before police. And the petitioner is having no criminal antecedent, and therefore the bail application may be favorably considered. Delay copy of charge sheet.
My lord.
The Lord and Counsel for the petitioner files the copy of the charge sheet which is taken on record. The Lord and Counsel for the state submitted, while not disputing that the petitioner's implication in the case is based on confessional statement of co-accused persons before police, submitted that the petitioner was charge-sheeted, showing him as an absconder. Considering the submission made by the land counsel for the respective parties, nature of accusation against the petitioner, since the implication of the petitioner is based on confessional statement of co-accused before police, keeping in view the ratio laid down by the Honorable Supreme Court in case of Tufan Singh versus State of Tamil Nadu, I am inclined to release the petitioner on bail allowed. Yes, next.
Item number 25.
May I please? Your Lordship directed state to take instruction.
On instruction.
The status of that interim,
I am filing the
interim
uploaded.
bail passed by the Supreme Court.
I am filing by way of memo, the order passed by Honorable Office.
We use the order of the Honorable Supreme Court so and so, from which it revealed that interim protection order has been passed against the arrest of the petitioner, and also it has been tagged to so and so. Submitted, the case is now. Let a copy of the order of the. We will obtain instruction about the status of the case of so and so. हाँ कौन है ला देखिए ये देखिए
The interim order made absolute.
So what do you want now?
For the to intimate the court. It is. And the trial is going on. He is attending the court and with
right, because you have been granted bail by the Honorable Supreme Court.
my lord. It is my duty to intimate the court.
Right, obviously.
Yes.
The item number 25. The Learned Counsel for the petitioner has produced the order dated
9/8 of
9th August 2023 of the Honorable Supreme Court, passed in Criminal Appeal number 2366 of 2023, which arises out of SLP criminal number 11086 of 2022, in which the interim bail order dated interim bail order passed by this court, which was extended by the Honorable Supreme Court in IA number 1187 of 2022 by order dated 12/8/2022, was made absolute and directed to continue until process is complete. The Learned Counsel for the petitioner, the memo is with a memo, which is taken on record. Learned Counsel for this wants to submit that in view of the order passed by the Honorable Supreme Court, he doesn't want to praise this application. Accordingly, the bail application is disposed of. Yes.
Item number 32.
ଆଜ୍ଞା।
Is it first application or earlier rejected?
My lord, this is the third application. The first application, my lord, was pleased to reject. My lord was pleased to direct the learned trial court to conclude the trial by 2021. Thereafter,
What is the number?
That is, my lord,
First BLAPL.
first bill 6967. No, 7380 of 2020. 7380 of 2020.
That is the first application.
That is the first application.
7380 of 2020. That order is here, and it while rejecting the application, there was a direction to expedite the trial and if possible to conclude by end of June 2021. Right.
Thereafter, your lordship, as the trial was not completed, the petitioner moved before your lordship, and my lord has granted the interim bail for certain period. And that is the BLAPL number 6967 of 2021. And order is 24, order is 12/1/2020. 12/1/2022.
21.
But you have mentioned it is that 31/3/2022 in your cost title.
Interim IA 31/2022 ଟା IA interim application.
ଆପଣ page 2 को आसନ୍ତୁ.
Page 2
of the bail application.
My lord.
ଆପଣ ଲେଖୁଛନ୍ତି 6967 of 21 was disposed of on 31/3/2022. ଲେଖିଛନ୍ତି ନା ନାଇଁ?
My lord, my lord. ସେଟା page 5 ରେ clarify କରିଦେଉଛି. Page 5.
Clarify କଣ ଏତେ ଦରକାର?
ଟିକେ
ସେ order କଣ ହେଲା ସେ ଯୋଉ BLAPL 6967 of 21 ରେ କଣ ହେଲା?
ସେଥିରେ IA ଫାଇଲ କରିଥିଲେ 31/2022. ସେଥିରେ interim bail ଦେଇଥିଲେ my lord.
କେତେ?
interim bail ଦେଇଥିଲେ, ତାପରେ ମୁଁ ସରେଣ୍ଡର କଲି।
କେତେ ମାସ ଦିଆ ହେଇଥିଲା?
24/1/2022।
ଅର୍ଡର କପି କାଇଁ? ଏଟା ବାହାର କଲ ଏଇ ଯୋଉ BLAPL number 6967.
Start from 13/1/2022 and the petitioner.
Please wait. 6967 लिख लो ना?
Again, sir.
2021.
31/22।
बाहर करो ऑर्डर टा बाहर करो कौन है?
ऑर्डर डेटेड 12/1/22।
12/1/22 कर दो। स्क्रॉल डाउन कर दो। the interim bail टा है ची IA रे dispose of है ची so and so shall surrender on। तापरे स्क्रॉल डाउन कर दो। हाँ तापरे ला 28/1 रे फाइनल ହେଲା produce the surrender certificate କଣ ହେଲା ଆପଣ? ସେଟାରେ ଆପଣ ଯାଇଥିଲେ interim bail କିଛି period ପାଇଁ। ଆଉ ଟିକେ back କଲ। ଟିକେ ରୁହ। ଏଇଟା for temporary period ଯେ ପୁଣି ସେଟା କଣ finally କଣ dispose of ହେଲା କଣ order back କରିଯାଉ। ନାଇଁ ଯୋଉଟା ତଳକୁ scroll down କର ତଳକୁ ଆଉ ଟିକେ 12/1/2022 ରେ ଥିଲା ସେଟା IA ଟା ମୁଁ order ଦେଇଥିଲି ତାପରେ କଣ ହେଲା ତାର finally କଣ ହେଲା order?
Finally reject ହେଇଗଲା।
ଆଚ୍ଛା
ମୁଁ ସରେଣ୍ଡର କଲି। तापरे that bill application was finally, and my humble submission is that all other accused persons has been released.
You are in custody since 9/4/2019.
Well,
So now what is the
2019
status of the trial? How many witnesses have been examined?
4 witnesses only examined. That was in the way back in the 2019, and thereafter prosecution has not examined any witnesses here.
Charita witness ହେଇଛନ୍ତି କେବେ କହୁଛନ୍ତି?
Charita witness ହେଇଛନ୍ତି PW1 was examined on
Last witness କେବେ ହେଇଛି ଦେଖନ୍ତୁ PW4.
PW4 25 जुलाई 2019
25 जुलाई
25 जुलाई 2019 2019
2019 ପରଠୁ ଆଉ ସାକ୍ଷୀ ହେଇନାହାନ୍ତି?
ତାପରେ ଏଟା କ୍ରସ୍ ଏକ୍ସାମିନେସନ ସରିଲା 26/8/2019
2019 ପରଠୁ ଆଉ ସାକ୍ଷୀ ହେଇନାହାନ୍ତି ଏହା କହୁଛନ୍ତି ତ? ଠିକ ସେ ବୁଝିଛନ୍ତି କାଉନସିଲ କୋର୍ଟ ତଳ କୋର୍ଟ କାଉନସିଲ କୋର୍ଟ ବୁଝିଛନ୍ତି?
କାଉନସିଲ କୁ ବୁଝିଥିଲେ ଓକିଲ।
All right, let the status report come then. Lekhundu, the learned counsel for the petitioner submitted that this is the third successive bail application of the petitioner, and the earlier two bail application of the petitioner in BLAPL number 7380 of 2020 and BLAPL number 6967 of 2021 were rejected, though in the second bail application he was granted interim bail for some time. Learned counsel further submits that he has received instruction that in the trial court only 4 witnesses have been examined, and PW4 was examined on 25/7/2019. Custody likely. Petitioner is in judicial custody since 9/4/2019. In view of such submission, let a status report be called for from the learned trial court, that is court na kundu.
Second additional session
judge Puri in
ST case number 7/144 of 2019.
7/144 of 2019 है ना? Second additional session judge Puri. File be placed before the registered judicial, who shall intimate so and so, usual order after ensuing puja holidays. Yes.
Item 34.
Item 34. I have filed the fresh Vaklatnama. I have filed the Vaklatnama on 9/8/2023, Lordship.
Kahanar Vaklatnama?
Sujogan Divedi and Associates.
I have not given the consent.
Yes, Lordship. The previous counsel has given the consent, and I have.
This is on my power. But I have.
Let the Vaklatnama.
Vaklatnama asile jana padibo se kujandi with consent file heichi beli.
Let it come tomorrow.
Apanako associate of consent di dinanti to?
No, sole power more ଅଛି।
ना आपण सोल पावर नाही, आपणको सहित आर महापात्रंकर पावर अछि। लिस्ट देखुनांती कॉज लिस्ट रे वकालतनामा फाइल ହେଇଛି, वकालतनामा रे आपणको ना लेखा ହେଇଛି ଏବଂ राजेश महापात्रंकर ना अछि, दी जन जाक साइन करछंती। तेणु आपण जदिओ न देइथिबे, जदि आपणको एसोसिएट कंसेंट देइथिबो, ताले सी जदि वकालतनामा फाइल कले विथ कंसेंट, तार असुविधा कोन? Associate को पचारिछंती consent देइछि कि नहीं?
Yes sir, tell me sir, now here.
देखो, it is stated by that at the bar that Mr. Suryakant Dwivedi and his associates have filed power. let the registry place the wakalatnama on record. Please this matter next week or then dekhiyo asu. Item number 34 na. Suryakant Divedi.
Item number 66. It is filed since 9/1/23, and in fact, I made a mention on 4/8/23. 66.
You wait and just take.
No, my landlord is saying that the file is not there because I have not mentioned in the first hour.
Mr. Mishra is there online.
Mr. Mishra.
Correct.
66.
Mr. Mishra, are you able to hear me?
Yes, my lord. I am speaking from my office at Bhubaneswar.
No, it's all right. The Mr. Kanungo said that you have given the evidence affidavit of one more witness to him.
I have given one witness.
So
That
since there was an understanding that it is to be completed by the puja vacation, that is by 19th of October 2023.
Yes,
so I just want to know that how many further witnesses you are to examine, and if so, why didn't you supply the evidence affidavit of the other witnesses? Because Mr. Mishra is stating that that will not take much time, maybe 15-20 minutes. So what is your...
No, I have given evidence affidavit of Advocate Santosh Lenka.
Right.
By email.
Right.
Then by Monday, I will give evidence affidavit of Prashanta Kumar Mahanti Advocate and Chartered Accountant Surya Mahapatra.
Okay.
By Monday. And
Okay.
16, 17, 18,
Ah.
these 3 days, 3 witnesses will be sufficient.
So by 18th it will be over, right?
No, by 18th, evidence of 3 witnesses will be over. Thereafter, I have election agent Shakil Khan and Dr. Sophia Firdaus. That will take hardly 1 or 2 days after vacation.
So, no, there was an understanding that we will finish it after we would have taken off argument after the puja vacation.
That will be deferred by 3-4 days, not much.
So, you are proposing, apart from the witness evidence which you have already supplied, you are proposing to examine 3 more witnesses prior to puja holidays.
No, 2 more witnesses. Prashant Kumar Mahanti and Surya Patri.
Okay, why don't you give the evidence affidavit of those 2 also by tomorrow? Because tomorrow it's the date fixed at 2 o'clock it will be taken out.
Yes.
So if you give the evidence affidavit so that they will prepare and on 16th it can be taken off, 16, 17.
My suggestion to your lordship is kindly bring the matter on Monday so that Santosh Lanka advocates evidence can be completed on that. By that time, I will give evidence.
Tomorrow we will complete Santosh Lanka.
Prashanta Kumar Mahanti and Surya Mahanti.
No. If the evidence, which evidence you have received?
Santosh Kumar Lanka, advocate.
You have already received?
Yes.
Okay, they are telling that Santosh Lanka's examination will be completed by tomorrow itself.
I am suggesting to bring the matter on Monday so that by that time I can give evidence affidavit of 2 other witnesses.
No, it is already coming tomorrow. It is already coming tomorrow for at 2 o'clock. It has been ordered, so it will come tomorrow at 2 o'clock, and this Santosh Lanka shall remain present to be examined in chief if it further requires, and also he is to be cross-examined, and Mr. Kanungo and submits that it will be over by tomorrow itself. So if that witness is over by tomorrow, then the next witnesses, 2 more witnesses.
I will give by Monday. They will examine them, cross-examine them.
Why don't you give by Sunday so that I can keep it on Monday and Tuesday and finish it. I don't want to keep it to the last date, that is on Thursday. I want to finish it. I want to finish it by 18th itself.
Yes.
Because that last working day, you know that half of the code, so all these problems are there on the last day.
Even tomorrow also.
Yeah.
Even tomorrow also I have information, there may be a reference. And the witness for your lordship's information is a practicing lawyer. We have already made him waited for 2 days. Therefore, my suggestion is kindly bring the matter on Monday. Santosh Lanka evidence I have served. I will give them more evidence on affidavit of 2 more witnesses. 16, 17, 18 will be covered by that. Subject to your lordship's approval.
Tomorrow let it come, my lords.
Tomorrow it is coming. I have already ordered.
Monday, if my learned senior wants Monday, okay, my lords. Tuesday, Wednesday, we can complete all the witnesses.
No, ask your witness to remain present, Mr. Mishra. That Santosh Lanka.
Yes.
He has to remain present tomorrow at 2 o'clock. Okay.
Yes.
So let us see. If there is no reference, it can be over by tomorrow itself.
Yes.
Okay.
Yes, no problem. That will be done. That can be done.
All right, that's all. Maybe that we usually last Friday it is to be held, but this month's last Friday is a holiday. That means the 20th is a holiday. So maybe I do not know this information which. Okay, so let us begin.
Oblige.
Call the matter. Case number, you please give to the Land and State Council so that you will bring.
Another matter, Lordship had earlier fixed this matter to 12th, Lordship.
Ah.
The IA regarding the health of the wife. Subsequently, the petitioner has been referred to SCB, and I have filed IA today only, Lordship. It's IA number 136.
No, the matter is in the list.
No, Your Lordship. It
So-
was earlier fixed to be taken up on 12th, Lordship.
Don't give the memo, it will
Yes,
come.
Lordship.
Yes, call the matter.
Item number 8.
Wait, please, Your Lordship. Lordship, this is the second journey of the petitioner, Lordship. Lordship, the alleged offense under section 20B, 2C and 29 of NDPS Act, Lordship. Earlier, the petitioner, item 8. Lordship, earlier by annexure 2, page 20. Lordship has disposed of this matter, stating to be completed within a period of 6 months. That was passed in the year 2021, Lordship. After that, only 4 witnesses have been examined out of 6, and the last witness examined was in the year 2021, Lordship. Lordship, may I kindly have a glance at up-to-date audit reports.
Mr. Das, there was a direction in the year 2021 to conclude the trial within a period of 6 months. But by now only 4 witnesses have been examined, and he is right that the PW4 was examined on 4/8/2021. That means for last 2 years and more there is no witness. So, but you are a man from which area?
Local man, Lordship.
Local man.
Yes, Lordship.
Are the Land Council for the petition, Land Council for the state. Land Council for the petitioner submit that the petitioner is in judicial custody since 23/6/2019. When he approached this court for the first time in BLAPL number 4778 of 2020, same was rejected by order dated 21/2021. However, taking into account the period of detention of the petitioner in judicial custody, the London Trial Court was directed to expedite the trial and to conclude the same within a period of 6 months. Land Council submits that by now only 4 witnesses have been examined in the trial court. What is the total number of witnesses?
6 witnesses, Lordship.
Out of 6, 4 witnesses have been examined, and the last witness, that is PW4, was examined on 4/8/2021. He has produced the order sheet of the Land Trial Court, which is taken on record, along with the copy of deposition of those witnesses. Land Council submit that the petitioner is a local man and there is no chance of absconding, and therefore the bail application may be favorably considered. The order sheet produced by the Land Council for the petitioner along with the deposition copies are taken on record. Land Council for the state has no serious objection to the grant of interim bail. Considering the submission made by the Land Council for the respective parties, in view of the commercial quantity of ganja seized in the case, and bar under section 37 of the NDPS Act, while not inclining to release the petitioner, on bail on merit, but taking into account the period of detention in judicial custody, slow progress of the trial, and since the earlier order passed by this court has not been complied with, I am inclined to release the petitioner on interim bail for a period of 3 months. Yes.
Item number 20. Item number 36.
May I please, ma'am? Your my
36.
lord is inside the custody since 6/9/2017, my lord. Offense under section 302, 341, 506, 34 IPC.
So, perhaps this is not your first application.
This is fifth, 1, 2, 3, 4, sixth application.
Sixth application.
I have mentioned in the cause title.
No, that's all right. So, but has been held in the earlier bail application.
Your lordship, kindly have a glance. Only in 3646 and 5177, in these two applications, interim bail was granted in first 3 weeks and 4 weeks. And other applications were rejected. Third bail applications was disposed of on, that is 1/20/2021 on August 2021, directing to complete the trial within a stipulated period.
And in the meanwhile, out of charge sheet witness 22, 9 witnesses have only been examined. And all the co-accused persons were granted bail.
No.
Except this
What is the total number of charge sheet witness?
22, my lord.
How many of them have been examined?
Rejection order shows 9 witnesses have been examined.
So have you filed the deposition copy?
No, deposition copies I have.
Then?
3 deposition copies.
No.
9 deposition copies I have filed. 3 to 9. 3, 4, 6, 7, 8, 9. Rest I have not filed.
But this PW9 seems to have been examined on 24th November 2022.
22, my lord.
For what is the present position?
Present position. Since it is circuit court, my instruction is that no trial has been. Additional sessions is going for circuit at Visham.
What is the offense here?
302, my lord.
And if 9 witnesses have been examined, what they have stated against you?
So far, I have filed the deposition copies of some of the statements. They have not whispered a single words, except there is a civil dispute between the parties.
Mrs. Patnaik?
161 statement to jana pଡୁଛି ଯେ he is the main assailant. ସେତେବେଳେ ଗଙ୍ଗା ପାଣି ଧରିଥିବା ଟାଙ୍ଗିଆରେ
କାହାର 164 ପଡୁଛନ୍ତି?
ଏଟା 164 ନା, ଏଟା statement of witnesses ରଘୁ ବାଟ୍ଟା.
ସେ examine ହେଇନି ସେ?
he is one of the eyewitnesses.
ରଘୁ ବାଟ୍ଟା.
ତାପରେ
ମିଶି
କାଳୁ ପାଣି ପୁରା ଆଇଥିଙ୍କ୍ ଅଛନ୍ତି ସେମାନଙ୍କର. କାହାର deposition ଦେଖିଲେ ମୁଁ.
No, he has given that deposition copy annexure 2 series. It starts from page 13.
ଆଜ୍ଞା ରବିଗନ୍ତ.
ରଘୁ ବାଟ୍ଟା I think has not been examined. ମତେ ଯାହା ଲାଗୁଛି.
ଯେଉଁମାନେ ହେଇଛନ୍ତି ଏପର୍ଯ୍ୟନ୍ତ ସେମାନେ କିଛି କହିଛନ୍ତି କି? ଯେଉଁମାନେ ନ ହେଇଛନ୍ତି ଛାଡ଼ନ୍ତୁ.
ଜଣେ PW5 କହିଛନ୍ତି on relevant time I was in my house.
Page 15.
At that
and
went near to the spot. At there I found Videsi Khondapani lying dead and Ganga Pani, present petitioner, is coming towards our Sahi holding Tangia after killing Videsi Khondapani. Then the informant lodged the FIR. Police had been to the spot and seized the bloodstained earth and objects.
He has not seen the actual assault, but stated.
He cannot say the exact date.
But there are witnesses to
there are direct eyewitnesses.
So, who those witnesses have been examined or not, Mr.?
Those witnesses so far I have seen that Raghu Bhatt has not been examined, and wife also. The name of the wife is Srimati Dukhan Kandhapani. Or statement.
When you were taken into custody?
On
6/9/2017.
The date is correct, 6/9/2017, Mrs. Patnaik. Charge sheet dekhile.
Rejection order also shows, my.
Acha. And what are the offences under which charge sheet submitted?
302.
109, 506, 34.
302, 109,
506 and 34.
506, 34. 2017 ମସିହା ରହିଲାଣି ଆପଣ ଯଦି ଟ୍ରାଏଲ ରେ ଏପର୍ଯ୍ୟନ୍ତ 9ଟା ୱିଟନେସ୍ କରିଛନ୍ତି, କେତେ ଟୋଟାଲ ୱିଟନେସ୍ ଆପଣଙ୍କର?
22, my. Rejection order also shows, my. Page 24. Trial of the case is in progress. Out of 22 charge sheet witnesses, 9 have been examined.
9 मतलब जी main witnesses माने जो ना eye witnesses है ना, गोटे सुधी बाग, गोटे
ଆପଣ ଦିଥର interim bail ଯାଇଛନ୍ତି?
ଦିଥର ଯାଇଛି. That is also reflected in the rejection order. He has been released twice on interim bail by this honorable court and has not misused his liberty granted. That is paragraph number 2, page 24. Your lordship, kindly see. Learned counsel for the accused person submitted. His client is innocent.
Or the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner was taken into judicial custody on 6/9/2017, and he has been charge sheeted under section 302, 109, 50634 of the Indian Penal Code. Oblique दे दो. And in the trial court, out of 22 charge sheet witnesses, only 9 witnesses have been examined. Learned counsel further submits that twice the petitioner has been released on interim bail, and after availing the same, he surrendered at right time. He submits that no clinching evidence has come on record, even though in the statements of those 9 witnesses examined so far in the trial court, and therefore the bail application may be favorably reconsidered. Learned counsel for the state, after verification of the case record, submits that there are some eyewitnesses who are yet to be examined.
Charge sheet was filed on 4/1/2018.
The Sessions trial is of the year 2018, and it is the requirement. It was the requirement on the part of the public prosecutor to examine the material witnesses at the first instance. If the same has not been done, and in the process the petitioner has remained custody for more than 6 years, and witnesses examined so far has not stated anything against him relating to the commission of murder, it would not be proper to detain him further in judicial custody, particularly when he has not misutilized his liberty while an interim bail granted twice by this court. After considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the slow progress of the trial, and the fact that the petitioner has not misutilized the liberty, I am inclined to release the petitioner on bail allowed.
Obligement.
My lord, item number 37.
Item number 37.
My lord, this is a case under section 376, subsection 3 of IBC, and of course
May I please?
40.
Earlier bail was refused.
376 3 अछि Mr. Sahu.
Notice has already been sought, my lord, on 25/4/23.
No, it was issued on that day.
Yes.
Extra copy ଦେଇଥିଲେ?
ଆଜ୍ଞା ଆଜ୍ଞା 25 ସେଇ ଦିନ ହିଁ ଦେଇଥିଲେ।
25/4 ଆସିଥିଲା।
ଆଜ୍ଞା।
और ଆପଣଙ୍କ ରେକର୍ଡ କଣ ଦେଖଉଛି?
ନୋଟିସ ସର୍ଭିସ ନୋଟିସ ଚିଠି ଯାଇଛି କିନ୍ତୁ ଆସିନି।
And what about the statement of the victim?
Your lordship kindly peruse page 9, my lord.
ଚିଠି
The
ଯାଇଛି my lord.
incident happened around 2 years. On the day of incident, I was alone in my house. My parents had gone to outside for wages. At that time, the accused came to me and took me to Aska. We stayed in his sister's house for 5 days. During staying there, the accused has forcibly established the physical relationship with me in spite of my protest.
After staying there for 5 days?
5 days, the accused took me to Barampur. While we are present at the railway station, my parents came to me and about me the incident to whom I narrated the incident.
No, the main problem is about that age. She was just 15 years as she stated.
No,
He
15
stated
years. She was 13 years.
Okay.
The
He
incident happened
stated
around
19 years, my lord, deposition.
Huh?
ऊपर लिखছে 19 वर्ष बोले।
My age is 15 years ତଳେ ଲେଖିଛି।
ऊपर 19 बोले।
Court सेटा court assessment.
ଆଜ୍ଞା।
Court केमती assessment कर दूची 19 वर्ष में। बाप ये तो निजे ही कूची आओ।
And custody, my lord, since 4/3/2020. 4/3/2020.
But this
वर्ष रो
minimum punishment is for 20 years, Mr. 376.
Near about 4 years is in custody, my lord. Your lordship, liberty was granted. Move after.
Date of birth केवे?
Date of birth.
Victim रो.
I have no birth certificate.
Date of birth 18/2/2008. 18/2 चार्ज शीट रो अछि मु लिखि 18/2/2008 my lord.
2008 हेले ठीक होची से 13 वर्ष हबो घटना से 21 रे बोधे हिची।
They are moving here and there, my lord.
Cross examination कहूची that she had raised halla inside the bus when she was taken away, but nobody came forward to save me.
बस रे कोड हल्ला ई को जाइथिबे जे छोटो पिलाडा जणा पडुची सेटा।
4 वर्ष पाखापाखि रहिलानी। लॉर्डशिप कंसीडर एनी कंडीशन।
Are the learned counsel for the petition, learned counsel for the state, learned counsel for the petitioner submit that the petitioner was taken into judicial custody on Kebe
4/3/2020.
4/3/2020 and earlier bail application of the petitioner in BLAPL number 976 of 2021 5/3/2020 କହିଥିଲେ ଗତ ଥର 5/3 କରିଦିଅନ୍ତୁ। He has been charge sheeted under section 363, 376(3), 376(2)(n), 366 of the Indian Penal Code, read section 6 of the POCSO Act. Further submit that so and so approves this court 976 of 2021, which was rejected on as per order dated 9/11/2021. The petitioner was given liberty to renew the prayer for bail after examination of the victim
Lordship, offense. This is offense under section 302, 201, 34 IPC.
CD available. CD available.
9, madam.
So this case is filed since 29th June 2023, sir.
Okay.
And
Is it your first application, madam, or earlier rejected?
Earlier rejected, sir.
What is the number of that application?
Lawsuit BLFL 6595 of 2020. This Honorable High Court has been pleased to reject the bail application.
Just a minute, just a minute. Seven, 237. Under which charge sheet submitted?
302 to 201 34 IPC.
What is the position of the trial now?
Sir, already the main eyewitness of the case has been already examined, and there are total 8.
How many witnesses have been examined?
8, sir.
8 witnesses. What they have stated, have you given the deposition copy?
Yes, sir. I have filed, and the main eyewitness of this case is the daughter of the deceased and the present petitioner, sir. And she has not implicated the present petitioner in this case.
No, I just want to see the deposition copies.
Sir, kindly peruse the deposition of Mansi Bhesra, PW4, at page number.
Have you received the deposition copies, Mr. Das? Deposition copy? No, he says 8 witnesses have been examined.
But they have not solved any deposition.
ये deposition copy देखिए.
We have served the deposition of PW 5 to 8, sir, later on, after examination of PW 8.
Some of the deposition, 4 deposition copy they have annexed matter, up to 4.
Yeah, yeah.
ଚାରିଟା ପରେ ଆଉ ଜଣେ କେମିତି ନା
You have given the deposition copies of 4 witnesses.
I have served the deposition copy of PW 5 onwards on dated 29th September 2023, sir.
29 September.
Yes, sir.
Where have you filed? It's not there. It's not on record.
Sir, I have uploaded the same.
Have you got those copies with you now?
Yes, sir. I'm showing this. PW5.
No, it's all right. Unless you send it, unless the copies is given to the State Council, he has a right to know what the witnesses have stated, and
Sir,
you
the main witness, eyewitness of this case is Mansi Besra. Your Lordship kindly peruse the cross-examination of Mansi Besra at page number 37. In her statement, she had not implicated the present petitioner. My Lord, kindly peruse the cross-examination, para 1.
Cross-examination starts from para 2.
Yes, sir, para 2. It is a fact that I have not stated to magistrate that my mother grabbed my father and assaulted by means of knife. It is not a fact that I have not stated before the magistrate that.
Which line you are pressing?
Sir?
Which line you are pressing of that cross-examination?
6. Line number 6.
Yes, read it out.
It is a fact that I have not stated to magistrate that my mother grabbed my father and assaulted by means of knife.
Yes.
He is the only eyewitness in this case.
No, maybe that grabbing part is not there, but maybe the assault part is there. 164 is that because in the chief examination he states that my mother phoned so and so in mobile. Sometime thereafter, Ranjit came to our house. My mother all on a sudden grabbed my father from the behind, and then both my mother and Ranjit assaulted to the head of my father by means of a knife. After killing my father, they took away the dead body outside and threw it on the road.
Sir, in the last line, kindly peruse, it is a fact that after taking dinner, we used to go to sleep, which means she didn't even see the occurrence. And it proves that she is not supporting the prosecution case. And on the same set of evidence, co-accused has already been released on bail. Co-accused Ranjit alias Hiran Singh.
Let hard Ms. Jayasri Behera and counsel to the virtual High Court Sambalpur submits that the petitioner is in judicial custody since 2012-2018 and she's a lady and charge sheeted under section 302-201-34 of the Indian Penal Code. 8 witnesses have been examined so far in the trial court, and PW4 is the material witness on behalf of the prosecution. And though in the chief examination she has supported the prosecution case, but in her cross-examination she has given a go-by to the earlier version, and in view of the cross-examination cannot be PW4 cannot be the evidence of PW4 cannot be acted upon, and since there is slow progress of the trial, the bail application may be favorably considered. And counsel for the state oppose the prayer for bail. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced so far in the trial court, the period of detention of the petitioner in judicial custody for more than 4 years and 9 months, and since the petitioner is a lady, keeping in view the proviso section 437(1) CRPC, I am inclined to release on bail allowed.
Item number 41.
May I please, Lordship?
File interim bail.
Hmm.
What interim bail file करछंती on the ground of illness of wife.
ସେଇଟା interim bail Lordship କରିବି।
ସେଇଟା
No,
prescription?
no instruction.
Interim bail ର ଆମ
ଏଇଟା permitted withdrawal Lordship.
IA number so item number 41. IA number 900 of 23. This is an application for interim bail. The land council for the petitioner doesn't want to praise this application. Accordingly, IA stands disposed of as not pressed. Yes. What is the main bail application?
It is the second one Lordship. On the first occasion, Lordship, the application of the petitioner was dismissed as non-prosecution. That was VLAPL number 3036 of 2020. It is case of 302 and
in custody since
Lordship 13/11/2019.
Charge sheet under section?
Charge sheet under section 341, 294, 506, 307, 302, 34 IPC.
What is the name of the deceased?
Manoj Naik, Lordship.
And there is an injured.
Lordship.
What is the name of the injured?
Injured Lordship.
Manoj Naik is the deceased. Injured is?
Injured Lordship.
Goli Naik.
Huh?
Goli Naik.
गोली नायक रो स्टेटमेंट रे देखिले कोन से कहूची आप
गोली नायक अछंती आ जने अछंती इंजर्ड उला नायक
उला
आज्ञा
से नै कोन कहउछंदी आनार कोन
आज्ञा
या नाला बाबूलाल नायक
There is a case and a counter case.
Wait, let's.
ନାୟକର ପୁଅ ପୁନିଆ ନାୟକର ପୁଅ ପାଣ୍ଡୁ ନାୟକ ଓ ଭଗବାନ ନାୟକର ପୁଅ ବାବୁଲା ନାୟକ ଜାତି ଧରି ପୁଣି ତାକୁ ମାରିବାକୁ ଯିବା ବେଳେ କାତି ଧରି
ଏଇ ବାବୁ ନାୟକ ତ
ପେଟିସନର ମୋର ହାତ ଖଣ୍ଡିଆ ହୋଇ ରକ୍ତ ତାକୁ ବି ବାଡେଇଛନ୍ତି ମୋର ହାତ ଖଣ୍ଡିଆ ହୋଇ ରକ୍ତ ବାହାରିଲା ସାଙ୍ଗେ ସାଙ୍ଗେ ଡୁଙ୍ଗୁରୁ ନାୟକ ଗୋଲି ନାୟକ ବାମ ଗୋଡକୁ ଟାଙ୍ଗିଆରେ ହାଣିଲେ
କିଏ
ଆଉ ଦି ଜଣ ଇଞ୍ଜୁର୍ଡ କୁ ଟାଙ୍ଗିଆରେ ହାଣିଲେ ମୋର ନାତି ମନୋଜ ଘଟଣା ସ୍ଥଳରେ ମରିଯାଇ ଥିବାର ଦେଖି ସେମାନେ ମତେ
ମନୋଜ କୁ କିଏ ମାରିଲା
ପୁନିଆ ବାବୁଲାଲ ନାୟକ ଓ
ଆଉ ଥରେ ଦେଖନ୍ତୁ
read one statement of
ପଢୁନାହାନ୍ତି କଣ ଅଛି ଆଇ ୱିଟନେସ ର ଅଛନ୍ତି ଆଇ ୱିଟନେସ ପଢନ୍ତୁ
ମୋର ନାମ ଭିକାରୀ ନାୟକ ବୟସ 52 ବର୍ଷ
ସେ କଣ ଆଇ ୱିଟନେସ ଭିକାରୀ ନାୟକ ପଢନ୍ତୁ
ଏହି ସମୟରେ ମୋର ଘର ସାମ୍ନା ରାସ୍ତା ଉପରେ ପାଟିତୁଣ୍ଡ ଶୁଣି ବାହାରକୁ ଆସି ଦେଖିଲି ଆମ ସାହିର ବାବୁଲା ନାୟକ ଓ ମନୋଜ ନାୟକ ଝଗଡା ଲାଗୁଛନ୍ତି ମୁଁ ସେମାନଙ୍କୁ ଛଡାଇ ନିଜ ନିଜ ଘରକୁ ଯିବା ପାଇଁ କହିଲି ସେମାନେ ଚୁପ୍ ହେବା ପରେ ମୁଁ ଘରକୁ ଚାଲିଗଲି କିଛି ସମୟ ପରେ ପୁଣି ଥରେ ଖୁବ୍ ଜୋରରେ ପାଟିତୁଣ୍ଡ ଶୁଭିବାରୁ ପୁଣି ବାହାରକୁ ଆସି ଦେଖିଲି ଆମ ସାହିର ପୁନିଆ ନାୟକ ରାସ୍ତା ଉପରେ ରକ୍ତ ଜୁଡୁବୁଡୁ ହୋଇ ପଡିଛି ମନୋଜ ନାୟକକୁ ବାବୁଲା ନାୟକ ଜାବୁଡି ଧରିଛି ସେହି ସମୟରେ ପୁନିଆ ନାୟକର ପୁଅ ଗାଣ୍ଡୁ ନାୟକ ମନୋଜର ମୁଣ୍ଡକୁ ଗୋଟିଏ କାଠ ଫାଳରେ ଖୁବ୍ ଜୋରରେ ପାହାର ଦେଲା
କିଏ ଦେଲା
ଗାଣ୍ଡୁ ନାୟକ ଖୁବ୍ ଜୋରରେ ପାହାର ଦେଲା ମନୋଜ ତଳେ ପଡିଗଲା ତାର ମୁଣ୍ଡ ଫାଟି ରକ୍ତ ବାହାରୁଥାଏ ଠିକ ସେହି ସମୟରେ ବାବୁଲା ଧରିଥିବା କାତିରେ ମନୋଜର ବେକକୁ ହାଣିଦେଲା ମନୋଜର ବାପା ବିଦୁ ନାୟକ ଓ ମା ଗୋଲି ନାୟକ ମନୋଜକୁ ଉଦ୍ଧାର କରିବାକୁ ଚେଷ୍ଟା କଲା ବେଳେ ପୁନିଆ ନାୟକର ସାନ ପୁଅ ଟୁଙ୍ଗୁରୁ ନାୟକ ସେମାନଙ୍କୁ କାତିରେ ଆକ୍ରମଣ କଲା ମନୋଜର ଜେଜେ ବାପା ଉଲା ନାୟକକୁ ବାବୁଲା ନାୟକ ହାଣି ଦେବାରୁ ତାଙ୍କ
ଅନ୍ୟ କଥା ଛାଡି ଦିଅନ୍ତୁ. So far as deceased is concerned, first as it appears, you read the statement from which it appears that the Gandu Naik
is the first assailant.
is the first assailant. He assaulted by means of a spit on the head. Then you assaulted on the neck by a sharp cutting weapon. So that may be the cause of death.
No, the cause of death is due to stab injury, Lordship.
Huh?
Due to stab injury. There are 2 stab injuries on the body of the deceased, and on account of the said stab injury, the deceased were declared to be dead.
Neck injury nahi.
Nahi, neck injury nahi. Here, Lordship, the Punya Naik, there is a case and a counter case. That 2 persons died in both sides, Lordship. The deceased Manoj Naik assaulted to the another deceased is Punya Naik. By that time, this is the allegation, the rescue to the same, the Babula Naik who got hold to the Manoj Naik, the deceased. And the Punya Naik, the daughter of, sorry, son of Punya Naik.
No, you see, you made a submission that though the statement of the witness, eyewitness, is that you assaulted on the neck of the deceased by means of a kati, and but there is no injury on the neck. That is your submission. Is it correct, Mrs. Patnaik?
All the external injury number 3, my lord. One stab wound of spindle sept with incision so and so on the right side of the body, just anterior to right shoulder. 3 mm lateral to base of the neck below clavicle. One stab wound, another second stab wound, piercing upper lobe of right lung, present 2.5 centimeter below injury number 1. One hemorrhagic lacerated wound of size so and so near ear left.
Neck रे injury अछि
अच्छी neck रे injury अछि.
Stab wound अछि किंतु neck injury माने काती injury कातीटाକୁ ଯଦି पुरेई ଦେଇଥିବେ ତାହେଲେ ହେଇଥିବ injury ହେଇଥିବ କାତୀଟାକୁ ଏମିତି ମାରଲେ cut injury ଆସିବ କାତୀଟାକୁ ଯଦି pierce କରିଥିବେ ତାହେଲେ stab wound ହବ.
କାତୀର sharp point
ତାପରେ 4 number of parallel cut injuries also.
It depends upon how one person uses it. So it cannot be mechanically judged at this stage that it is not possible or not possible.
The person inside the custody more than 4 years, Lordship. More than 4 years inside.
ବର୍ତ୍ତମାନ trial position କଣ?
Trial Lordship as the counter case ଟାରେ warrant ହେଇଛି ସେମାନେ ଆଉ କେହି ଆସୁନାହାନ୍ତି 4ଟା 5ଟା ଖଣ୍ଡେ ସାକ୍ଷୀ ହେଇଛି ବାସ୍ ସେତିକି counter case ଟା warrant ନଥିଲେ କଣ ଗୋଟେ ଦିଟା case take
କେଇଟା case ଅଛି ଆପଣଙ୍କ ନାଁରେ?
ନାଇଁ ୟା ନାଁରେ ଆଉ case take ହେଇକି analogous hearing ତେଣୁ ସେମାନେ ଆସି ଆଉ ସାକ୍ଷୀ ଦଉନାହାନ୍ତି.
ସାକ୍ଷୀ ଟୋଟାଲ ଆରମ୍ଭ ହେଇନି ପର୍ଯ୍ୟନ୍ତ?
ନା ଆରମ୍ଭ ହେଇଛି ଆଉଟସାଇଡ ରୁ ଆସିକି ଦେଇଛନ୍ତି କିନ୍ତୁ ସେମାନେ ଆଉ 191 ମାନେ implicated in 191 PS case number. The counter case is 190. Both the cases now take and analogous hearing is going on by the trial court. When the counter case is issued, they have not moved to the court for reduce their evidence.
Rejection order ଅଛି out of 23 এটা ମାନେ rejection order is of 2/2/2023.
ସେଟା ଗୋଟେ ସାକ୍ଷୀ ଲେଖିଛନ୍ତି.
Annex 2 ରେ ଦେଇଛନ୍ତି. Out of 23, 3 numbers of witnesses have already been examined in this case. The informant and other key witnesses are yet to be examined in this case.
ଲେଖା ହେଇଛି out of 23 number of so and so, only one has been examined. One has been examined. The informant so and so.
2 order ଟାରେ Annex 2
Annexure 1 ଦେଖୁଛି rejection order dated 22/12/2022.
ତାପରେ ଆଉ ଗୋଟେ ହେଇଛି ତାପରେ Annex 2 ଟା page 13 ରେ ଦେଇଛନ୍ତି ଆଉ ଗୋଟେ extract of the order.
ଆଚ୍ଛା
ଆଉ ଗୋଟେ କିଏ ସେଟା ଗଣ୍ଡୁ ନାୟକ ପରା?
ନାଇଁ ଗାଣ୍ଡୁ ନାଇଁ ବାବୁଲା
ନାଇଁ ବାବୁଲା ନାୟକର ଅର୍ଡର ଟା ଦେଇଛନ୍ତି ଯେ କେତେଟା ୱିଟନେସ୍ ହେଲାଣି?
Produce the deposition copies of the witnesses. How many witnesses have been examined?
In the meantime, Lord, 3 to 4 witnesses as per the instruction. Today morning, I take instruction from the council conducting the trial court. The only difficulty is that the counter case, because of anybody issued in the counter case, and both the cases are hearing analogous hearing by the London trial court. They have not moved and adduced their evidence before the trial court.
Are the learned counsel for the petitioner and counsel for the state? The learned counsel for the petitioner submits that the petitioner is in judicial custody since 13/11/2019. It's a case and counter case, and charge sheet has been submitted under section 341, 294, 506, 307, 302 by 34 of the Indian Penal Code. And though the eyewitnesses, including the injured, have stated that the petitioner assaulted the deceased Manoj Naik by means of a kati on his neck, but the
ମନୋଜ ନାୟକ କାଠ ଫାଳିଆରେ ମାରିଛି ମୁଣ୍ଡକୁ ସରି ଗଣ୍ଡୁ ନାୟକ
ଗଣ୍ଡୁ ନାୟକ କାଠ ଫାଳିଆ ମାରିଲା, ତାପରେ ଇଏ କାତିରେ ମାରିଲା, but the neck injuries are stab wounds, which improvises the assault part of the petitioner, and in view of the period of detention in judicial custody, the bail application may be favorably considered. Learned counsel for the state, on the other hand, oppose the prayer for bail and submits that there are number of witnesses who have, including the injured persons, who have specifically implicated the petitioner in the assault of the deceased and the vital part of the body of the deceased. Considering the submission made by the learned counsel for the respective parties, the nature of accusation against the petitioner, the statements of the eyewitnesses as well as the injured, and the post-mortem report finding, while not inclining to release the petitioner on bail, but taking into account the period of detention in judicial custody and slow progress of the trial, I am inclined to release him on interim bail for a period of 3 months. Yes, disposed of.
Item number 44.
May I please response? In this case, my lords, petitioner was charge sheeted for the alleged commission offence, my lords, 302, 201, 34 IPC, my lords. He is in custody since, my lords, 10/9/19, my lords. Meanwhile, one of the co-accused person, Jagdish Barya, Vishwal, my lords.
Just a minute. Is it your first application or early?
My lords.
But 9217 of 2021, Jagdish Vishwal.
Vishwal, my lords.
He's a co-accused.
Co-accused, my lord. The principal accused, he has been released. Entire allegation against the Jagdish Vishwal, my lords. They also allow the bail option.
No, that bail application was rejected. That BLAPL number 9217 of 2020.
Thereafter, another bail option 1908, my lords, of Jagdish Vishwal, 1908 for 200.
Where is that order? Haryana. Yeah. So what do you say? This man is similarly situated like the other one.
My lords, the better footing than the Jagdish Vishal, my lords. Entire allegation against Jagdish Vishal, my lords. He stabbed the.
Jagdish Biswal has been granted bail. Mrs. Patnaik.
ଆଜ୍ଞା
ସେ କଣ ये same footing ନା କଣ ସେ? You are in custody since when?
My lords, 10/9 to 19 months. 10/9/2019.
Charge sheet under section?
My lords, 302, 201, and 34 IPC, my lords.
What is the name of the deceased?
Poilman Pramod Kumar Sahu.
Eyewitnesses are there.
Yes, my lords.
Name one eyewitness.
11 and 12 months. We told 11 and 12 months.
deposition
So what is the evidence copy?
ଆଜ୍ଞା
ହଁ ନାଇଁ କଣ କହିଛନ୍ତି?
PW11 main allegation କରିଛନ୍ତି Jagdish Biswal against it. That accused Jagdish Biswal gave a blow with the help of a knife to Pahaliman and he fell down. But ଦି ଜଣ ଯାକ ଥିଲେ, two persons were there who were abusing and raising halla. Accused Jagdish Biswal gave a blow with the help of a knife to Pahilman and fell down. Then the salesman tried to save Pahilman, but the accused Jagdish also assaulted him with knife. Then both the accused persons left the cycle and ran away. Then
No, I have taken into account that statement, but in the cross-examination somewhere he has stated perhaps that he had no prior acquaintance with the accused and he had seen the accused for the first time in court.
ଆଜ୍ଞା TI parade ହେଇନି ମାନେ
TI parade ହେଇନି, court ରେ ପ୍ରଥମ ଥର ପାଇଁ ତାକୁ ଦେଖୁଛି, ଅର୍ଥାତ୍ spot ରେ ସିଏ ନାହିଁ। ସେ କହୁନି ଯେ ମୁଁ spot ରେ ଦେଖିଥିଲି ତାପରେ ଆସି court ରେ ଦେଖିଲି, ସେ କହୁଛି ମୁଁ first time court ରେ ଦେଖିଲି।
Bima Prasad, because
And he had no prior acquaintance. 12 ମଧ୍ୟ କହୁଛି, but the assault part is attributed to Jagdish, na?
ଆଜ୍ଞା salesman is an injured eyewitness
Manager.
manager na
The manager of the Bhat team of the Bhat clubs.
ସେଟା କିଏ manager ଟା
Liquor shop manager.
Havildar ତାର witness ଟା ଖାଲି I don't know. Manager ଟା is an eyewitness and injured eyewitness. ତାର ତା ନାଁଟା କଣ manager
But if Jagdish has been released on bail, this man stands in a better footing.
Again, that your lordship can consider.
He is in custody since 10/9/2019.
My lords.
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submit that the petitioner is in judicial custody since 10/9/2019 and he has been charge sheeted under section 302(201) by 34 of the Indian Penal Code. He further submits that the co-accused Jagdish Biswal has been directed to be released on bail by this court in BLAPL number 1908 of 2023 as per order dated 10/5/2023, and the petitioner stands in a better footing and therefore the bail application may be favorably considered. Learned counsel for the state, after going through the evidence supplied to her, evidence copies of the witnesses examined in the trial court supplied to her, fairly submits that as per the evidence of PW11, who is an eyewitness to the occurrence, the petitioner stands in a better footing than co-accused Jagdish Biswal. Considering the submission nature of accusation against the petitioner, the release of the co-accused on bail, period of detention in judicial custody. Reject it,
No, my lords. The first answer.
I am inclined to release the petitioner on bail allowed.
Pleasure.
Item number 45.
May I please, Your Lordship? Lordship, I am in custody in this case. It is a fresh bail application, Lordship. And so far, the other co-accused person bail application is considered accordingly, Lordship. This bail application has been listed before, Lordship. And I am in custody since, Lordship, 16/6/2023. And out of 46 FIR named accused persons, Lordship, 15 have already been released with bail. I haven't supplied the copy, Lordship, and also supplied it to the London State Council earlier, Lordship. And so far, the statement, Lordship, one Mongoli Jana, as per his statement, Lordship, all the accused persons, including the president, those who released on bail also, assaulted the deceased. The name of the deceased, Lordship, Chitrasan Jana. And when Chitrasan Jana, your Lordship, bathing in the village pond, this petitioner and others, those who were released on bail, Lordship, surrounded him and started assaulting.
What are the weapons used?
The weapon of choice is iron rod, your Lordship. And so
It's a omnibus nature of allegation.
Yes, my lord.
No specific overt act
No,
against
no.
him. 46 persons assaulted.
46 persons so far FIR is concerned, Lordship.
What are the injuries? Nature of injuries?
Arms Act भी अच्छी. Arms Act
Nature
भी
of
अच्छी.
injury,
There is
Lordship.
No, Mr. She said that some of the co-accused have been granted bail.
yes, yes, they have been active and
It's a
named FIR named accused persons almost standing in the same footing. my
but you are an absconder for so many days.
No, your Lordship, charge sheet in this case, your Lordship, first of all, your Lordship, the preliminary charge sheet is submitted, your Lordship, 13/7/2017. By that time, my name was not there, your Lordship. The final charge sheet came, Lordship, 31/8/2019. There I found my name is there and inventory is issued against me. Then I have been arrested, your Lordship, 16/6/2023, your Lordship.
But
In the
FIR
meanwhile, your Lordship, similar placed. So,
FIR ରେ ତାଙ୍କ ନାଁ ଥିଲା.
No, he says the name is there, but
there,
no
but not
specific overt act against. By the way, the weapon of assault is by iron rod.
Iron rod and your Lordship is stated to be revolver, your Lordship.
Revolver.
Yes, my Lord. 25/27 Arms Act is there, your Lordship.
What are the offences under which you have charge sheeted?
I mean, charge sheet, your Lordship, 147, 148, 302.
147.
147, 148. 302, 120B. 145 IB, section 25 from Arms Act, Lordship. All the accused persons charge sheeted, your Lordship, so I'm offense.
25, 27.
Yes.
Injuries ଟା ପଢିଦେବେ.
Ah.
All the injuries mentioned above are antimortem in nature. Age of the injuries within 6 to 12 hours of PM. All the abrasions are simple in nature and caused by contact with hand and blunt surface. All the fractures mentioned are grievous in nature, caused by hard and blunt object. 5. Lacerated wound mentioned on scalp is grievous in nature and caused by hard and blunt object. 6. Track found on dissection of left upper limb and might be due to bullet injury, but no pellet found both on dissection and X-ray submitted to office. So these are the injuries. Injuries on dissection found on right upper limb may be due to hard object in a sharp end, as it is grievous in nature. These are the kind of injuries.
So what is the bail order of those co-accused
That's
persons?
supplied, your Lordship.
ବହୁତ ଜଣ ବାହାରି ଯାଇଛନ୍ତି.
I am similar putting like your Lordship, Sagar Bolyar Singh in BLAPL on 4485/2019. And Robbie Gajendra, your Lordship, BLAPL number 6658/2017. Then Seshodev Bododana, your Lordship, BL number 547/20, your Lordship.
All right, heard the learned counsel for the petitioner. Learned counsel for the state submits that the petitioner is in judicial custody since 16/6/2023. He has been charge sheeted under section 147, 148, 302, 120B, 149 of the Indian Penal Code and section 25 and 27 of the Arms Act. The learned counsel further submits that the occurrence in question stated to have taken place on 31/3/2017, and as per the eyewitnesses account of Dhananjaya Chotray, Subhash Chandra Dala Singh Roy, the allegation of assault against the petitioner are omnibus in nature, and the co-accused persons similarly situated have already been released on bail by this court, and therefore the bail application of the petitioner may be favorably considered. Learned counsel for the petitioner files the bail order copies accused persons which are taken on record. Learned counsel for the state produce the case diary, place the post-mortem report, so also the statements of eyewitnesses, and doesn't dispute that the petitioner is similarly situated like the co-accused persons who have already been enlarged on bail. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, release of co-accused persons on bail, absence of any specific overt act of assault on the deceased against the petitioner, I am inclined to release the petitioner on bail allowed.
Pleasures.
Item number 48.
46, Millers. I am there. Item 46.
Mr.
मेंशन करनथले फाइल आसुनी
से कोन प्रथमरु कोन मेंशन जो माने करथिले तांकरी फाइल आनिचंदी तेणु आपणकर फाइल कोन मेंशन करनथिले सेतमे आनी नाहंती वर्तमान आपण मेंशन कले सी आनिबे काली टेकअप हबो नंबरटा टिपी रखिले से नेक्स्ट डाकुन
Lordships.
Item 48.
May it please your Lordships. The petition is in custody since 5/9/2021, your Lordships.
ठीक है आगु रिजेक्ट करथे हितला
Yes, your Lordships. It has been rejected, and on 20th of February 2023, and your Lordship had directed that I can renew my prayer if the trial is not finished within 6 months, your Lordships. He's in custody since over 2 years. NDPS Act. Quantity is a little high.
What is the date of custody?
Date of custody 5/9/2021, your Lordships.
Now, what is the position of the trial?
Position of trial has not been completed, your Lordships. Trial is still on, still now.
A status report we got.
Right, order sheet copy अछि
नहीं क्या copy
केम जानिबा मगे देलेनी
ई कोर्ट्स रे देखुची चलछि
कोन देखु
ई कोर्ट्स रे हियरिंग देखुची फॉर अ लॉन्ग टाइम नो बट द कोर्ट इज नॉट
मन कहले भी ऑर्डर शीट उडा को अपलोड करिया पे ऑर्डर शीट अपलोड केनी
नहीं खाली हियरिंग टा शो दी वर्ष रहलन may I just pray only for short period of
counsel for the petition and counsel for the state. Considering the submission made by the land counsel for the petitioner that the petitioner is in judicial custody since 5/9/2021, and in spite of the order passed by this court in BLFL number 4269 of 2022 in
this person belongs to Uttar Pradesh.
Uttar Pradesh?
Yes.
He's an outsider.
Okay, so you address verification to be made for cutting the order. Address verification to be made, and local sureties to be furnished to the land council for the state for verification. Land council for the petitioner submits that the petitioner is in judicial custody since 5/9/2021, and even though there was a direction to conclude the trial within a period of 6 months, as for order dated 20/2/2023 in BLAPL number 4269 of 2022, but the trial is continuing. Status report we called for. Put up this matter after entering Puja holidays. Yes.
Relationships.
Item 50.
Please, Your Lordship. My lord, this is the second.
Just a minute. फ्री कॉपी दे देवे ता एड्रेस वेरिफिकेशन करियो तो जो एसपी तक कांटेक्ट करियो सेटा को. Yes, is it first application?
My lord, this is the second joining of the petitioner. He is about 3 years in custody.
Wait. So, what is your first application?
First application, my lord, BLAPL 9735 of 22.
What order was passed in that application?
While disposing that application, your lordship directed the learned tribunal to expedite the trial, and in the first instance, the eyewitness should be examined.
What has happened in the meantime?
Out of there are 4 eyewitnesses. 2 have examined and they have not supported the prosecution. PW1 and 4, and the rest 2, despite of several summons, they are not coming, even refusing to come to court, my lord.
So, what is the deposition copy of the witness?
My lord, I have annexed it.
Who are those 2 eyewitnesses?
PW1 and PW4, my lord. 17 pages. PW1 Sunita Haika, and PW4 Ramani Dangiri.
Since when you are in custody?
My lord, 13/11/2020.
Charge sheet submitted under section?
My lord, 302.
Name of the deceased?
Basanti Khora.
Mr. Das, what he says that there are 4 eyewitnesses. Out of them, 2 have already been examined. That is PW1 and PW4.
Yes, ma'am.
And they have not supported the prosecution case.
Yes.
But the other witnesses have been repeatedly summoned. They are not coming forward to give evidence. So, what is the what those 2 witnesses?
They died.
Acha.
American direct IHE.
What are the names of those 2 eyewitnesses?
Basanti Benia.
Just a minute.
Santosh Mani Takri.
Santosh
Mani Takri.
Takri. TAKRI.
Takri. My lord. PW4 lastly examined on 22. On February, PW4 has been examined.
You got to attempt niya jo IIC jariya dekhiya no asile tapore. So, can you tell me that what is the next date fixed for trial?
My lord, to provide.
Provide. Just get the information from the local council. I am dictating the order. Just provide it. The Land Council for the petitioner submitted that the petitioner is in judicial custody since 13/11/2020. And out of 4 eyewitnesses to the occurrence, 2 of them have already been examined as PW1 and PW4, but they have not supported the prosecution case. And the other 2 eyewitnesses are not appearing to give their evidence in spite of repeated summons. And therefore, the bail application of the petitioner may be favorably considered. Learned counsel for the state submits that Basanti Benia and Santosh Mani Takri are the 2 eyewitnesses who are yet to be examined. And he submits that on the next date, steps shall be taken for production of those 2 witnesses to give their evidence. Considering such submission, let the IIC of Semilguda Police Station appear before the London Trial Court, that is Additional Session Judge Koraput, in city case number 19 of 2021 on or before such and such dates. तारीख of जो अनुଯାयी देवे से अनुଯାयी कर देवे. Receive summons in respect of witnesses Basanti Benia and Santosh Mani Takri, and ensure their attendance on the date fixed. List this matter in the week commencing from such and such date. If the aforesaid 2 eyewitnesses are examined, in the meantime, the Land Counsel for the petitioner shall produce the certified copy of their deposition, giving copies thereof to the Land Counsel for the state. Free copy of the order be handed over to the Land Counsel for the state. Yes.
Item 61.
Item 61, I am there, my lord. In VC, my lord. I mean VC. Your lordship has earlier rejected my bail application. That is at page 13, my lord. Page 13 of my bail application.
in 2017, which is more than 6 years, my lord.
Just a minute. Record number?
64. 64, my lord.
64.
Is my lord custody since 10,
Please,
10?
please, please wait. Is it your first application?
My lord. Here is a custody since 10/10/2017, my lord. This is more than 6 years, my lord. And date of occurrence, my lord, 1/10/2017.
Charge sheet under section?
363, 364, 376, 2I.
363, 364.
My lord.
Then?
376, 2I. 302, 201, 376, capital A. And section 5 and 6 of POCSO Act, my lord.
5 and?
5 and 6 of POCSO Act. Final.
So it's rape and murder. Kidnap, then rape, then murder.
My lord.
Cause disappearance.
My lord.
So?
So well, here is my lord, date of occurrence is 1/10/2017. It's a 5 p.m. my lord. And dead body found on 3/10/2017. That is 2 p.m. to 3 p.m. After.
How many witnesses have been examined?
Witness, my lord, total charge sheet witness 22. 7 number of witnesses are already examined. And the entire case is no eyewitness is there. And based on the last seen together, my lord. As per the statement of the informant, which is PW1, my lord.
No, you have given the deposition copy of
1 to
6
7.
witnesses.
7 number witnesses already.
PW6 was examined on 24th March 2023.
Next, my lord, PW7. Last witness, my lord. As per the PW1, my lord, that will be depend upon the last seen together, my lord. And there is no eyewitnesses are there. PW1 stated that I am just reading the relevant portion, my lord. I had taken Handia along with my wife at Purna Basti on date of occurrence. At that time, the accused was also taking Handia with us. After taking Handia, we were returning to our house, and the occurrence took place on the way to our house. PW1. PW1, my lord.
Yes.
And no other witnesses that is stated anything regarding this part, my lord. Next, my lord. PW 5, my lord. Wife of the PW1 man stated that we are in good terms with the accused prior to this incident. We went to Pune Basti to take Handia. And
but you are not filing the statements of the witnesses examined after PW6.
PW6, PW7 is the police witness, madam. I am given the total witness.
I have a glance on the PW5, madam. 3 years.
This is PW1.
PW3, madam. 5, madam.
5.
Second part.
There are 2 Sahis in our
village. One is
Purna
Basti and the other is Noa Basti. Both the Bastis are separated by one canal. Prior to about 4 years back, on the Sunday, I along with my husband, deceased, and another daughter, and the accused had gone to Purna Basti of our village. I was holding my younger daughter. The accused was holding the deceased, about 3 years old. At the time of returning to our side, my husband was also coming with us. I, with my younger daughter and husband, were proceeding. The accused who was holding the deceased, the accused with the deceased were following us. We reached our house thinking that the accused with my deceased daughter will reach the house later, but they didn't reach our house. So we started searching them. We didn't find them. On Tuesday, the village woman went to the Nala and found my daughter lying dead inside the water of the Nala. They intimated us. We found there was no flock of her body. She was found wearing her pant. There was injury on her ear and lip, might be caused due to the bite of the fishes or any other aquatic animals. We intimated the police. The police Babu came and lifted my daughter and from the disease from the water.
The date of occurrence is 1/10/2017, my lord, 5 p.m. And the dead body found on 3/10/2017 at 2 p.m. to 3 p.m. Here is a long time gap is present. My lord, as per the decision of the Honorable Supreme Court in
No, no, but you are holding the deceased,
My
who is aged about only 3 years old.
Only
My
3
lord.
years.
So how did you, if somebody has taken you or you left the deceased, you should have immediately told the parents. The parents just
My lord,
were proceeding ahead.
all are taken to my lord, Handia, my lord. And they also admitted, PW1 also admitted that drowsiness is there, my lord. They doesn't know about their daughter is there. So after that, they stated that
But what is the total number of witnesses?
22, my lord. 7 number of witnesses examined, including the police witness. Police witness is 2 were examined. And none of them supported the prosecution, my lord, case, my lord.
And as per the 27, the wearing apples are recovered from the leading to discovery by the present petitioner.
Leading to discovery, but there is a long time gap is present, my lord. Yes.
One man has been detained for 6 years,
My lord.
and
More
you
than
are
6 years.
examining only 7 witnesses.
My lord. No criminal antecedent is there.
No, this is a case. If it is proved, then it will be it can be hanged to death.
Yes, ma'am.
You see, rape and murder of a minor 3 years old child. The learned counsel for the petitioner submits that the petitioner is in judicial custody since 10/10/2017, and he has been charge sheeted under section so and so. And out of 22 charge sheet witnesses, only 7 witnesses have been examined, even though the petitioner has remained in judicial custody for 6 years by now. He further submits that no clinching evidence has come on record so far, and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail, placed the evidence of PW5, and submitted that the deceased was a minor girl, a child, is about 3 years old, and the offense is heinous in nature, and more material witnesses are yet to be examined, and therefore petitioner should not be released on bail. Considering the submission made by the learned counsel for the respective parties, the nature and gravity of the accusation, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention of the petitioner in judicial custody, I direct the London trial court to expedite the trial
Can I pay for interim bail, madam?
and conclude the same within a period of 6 months, from the receipt of the order and taking recourse to Section 309 of CRPC. The petitioner is at liberty to renew the prayer for bail if the trial is not concluded within the aforesaid period. Copy of the order be communicated
My lord,
to
can I
the
plead for
London Trial
interim
Court
bail?
for compliance. Yes, next.
Item number 66.
My lord, item 65.
66. Yes, Mr. Misra.
This is the fourth petition by the petitioners and the
Colonel?
fourth petition. So
Yes, yes, sir.
this is the fourth petition.
Uh-huh.
First two petitions were withdrawn. And third petition, it was disposed upon by this batch of the Court Lordship on 14/9/2021. That is 2690/21. While rejecting the application, the last paragraph your Lordship has held, in view of the eyewitness account one Ratnamani Pandey that the petitioner assaulted the deceased CORAM Pandey with Thenga along with other co-accused persons who are assaulted the deceased by various weapons in view of the number of injuries noted in the postmortem examination report. And the cause of death was on account of carniocerebral injury. At this stage, while not inclined to release the petition on bail, I direct the SGM to expedite the commitment of the case to the Court of Session, and trial court should do well to frame the charge, take steps. In the meantime, out of 22 witnesses, 17 are already examined. I just got information from the trial court advocate, and 4 are left out, including the IO and doctor. And the petitioners are in custody since my lord, more than 5.5 years, 11/3/2019, 18.
11/3/2018.
18.
So, what the eyewitnesses have stated?
They've implicated that Pandey. I got the certified copy. I've got the certified copy. If your lordship will see.
Of the witnesses examined in the trial court.
17.
No. Just what they have stated. One of the eyewitness you just read it
This
out.
Pandey, which your lordship has mentioned in the last order, he said that
he's examined as PW
6. Can I hand over to your lordship?
Yes, possible.
କେତେ ଦଉଥିବ 6 ମାସ ପ୍ରାଇଭେସି କେସ୍ ତ ଅଛି 5 ବର୍ଷ 6 ବର୍ଷ ଲଗାଉଛ ତ ସ୍କୁଟର ବାଣ୍ଟି
Okay, at the time of occurrence, I was standing in my outer courtyard,
taking
food. By that time, I heard shout as Morigali. When I came to the spot, I saw accused Mayadhar Code.
Yes, ma'am. Petition number 2.
Acha. Mayadhar Code assaulted by means of crowbar on the head of the deceased. Accused Sagar Pod, Surapod, and their mother assaulting him by means of Thenga. I called my paternal uncle to prevent the accused persons from further assaulting. What is the name of the deceased?
That is,
you have received the case diary, mister? So get the case diary.
And also let them solve a deposition copy.
Deposition copy.
No, I have got deposition copy up to 14, PW 15. The two to
You
examine
said that, no, whatever you have, Mr. Misra, you supply it. So, because it is only 8 is there, only PW.
PW 8, the rest is up to 15 is with me. And last 2
What are the injuries sustained by the deceased? PM report is there.
In the last occasion, your lordship dealt with that there are number of injuries.
It is relating to out of land dispute. Construction of Anganwadi worker, there was a dispute in the village, and they assaulted.
You have remained in custody for 5 years.
5.5 years, more than 5 years.
What I pray that counsel for the petition, land counsel for the state. Considering the submission made by the land counsel for the petitioner that the petitioner is in judicial custody since 11/3/2018. Petitioner, sorry. And they have been charge sheeted under section 341, 294, 506, 302, 336 by 34 of the Indian Penal Code. And out of 22 charge sheet witnesses, 17 witnesses have been examined. And after going through the evidence of the eyewitnesses, particularly the evidence of PW6 and the post-mortem report finding, and after hearing the land counsel for the state, I am inclined to release the petitioners on bail allowed. Yes.
Item number 69.
Please, Your Lordship. My Lord, the petitioner is in custody since 27/9/21, my Lord.
Just a minute.
CCC ଟା allow ହେଲା ତ?
It's a fast application.
Fast application, my Lord. Who are going to release on bail? I have annexed
What
three,
is
my
your
Lord.
date of custody?
Custody 27/9/21, my Lord.
Charge sheet submitted under section?
Charge sheet submitted 302, 120B, 34 of IPC and section 25 and 27 of Arms Act.
The name of the deceased?
My Lord, no eyewitness in the to the
Deceased
occurrence.
na the eyewitness.
My Lord, the deceased, my Lord, Deepak Kumar Mohan.
Date of occurrence?
And date of occurrence 24/9/21.
No eyewitness.
No eyewitness.
What are the circumstantial evidence?
Only implication on the statement of the co-accused and also confession of the petitioners before police and leading to discovery one gone, my Lord. And a confession before the witness of leading to discovery PW6 and 7, my Lord.
Gone recovery itla.
Gone recovery itla. I am giving the statement, deposition of PW6 and 7, that the leading to discovery of two witnesses.
Support kaleni?
Not supported, my Lord.
PW6 and PW7?
Yes, my Lord.
Right.
Two co-accused persons released on bail.
Wait. Nothing was seized, okay. Or the learning counsel for the petitioner, learn counsel for the state. The learning counsel for the petitioner submit that the petitioner is in judicial custody since 27/9/2021. He has been charge sheeted under section 302, 120B with 34 of the Indian Penal Code and sections 25 and 27 of the Arms Act. The occurrence in question took place on 24/9/2021, and there are no eyewitnesses to the occurrence. Case is based on circumstantial evidence, and the main circumstance is leading to discovery of one gun, which is stated to be the weapon of offense.
Two guns, my Lord.
Two guns.
Two guns.
Two guns, which are stated to be the weapons of offense at the instance of the petitioner on the basis of his statement recorded under section 27 of the Evidence Act. Learned Counsel further submits that witnesses to the leading to discovery having been examined as PW 6 and PW 7 in the trial court have not supported the prosecution case, and therefore the bail application of the petitioner may be favorably considered. Review the statements of the witnesses examined so far in the trial court. Learned counsel for the state to oppose the prayer for bail, considering the submission made by the learned counsel for the respective parties. Nature of accusation against the petitioner, absence of any direct evidence, nature of circumstantial evidence, since the witnesses to the leading to discovery have not supported the prosecution case, taking into account period of detention of the petitioner in judicial custody. I am inclined to release the petitioner on bail allowed.
Petitioners matter, two petitions.
Petitioners. এটা হলো item 69 তো
Item number 71.
May. Offense under section 302 and 34 IPC, my lord.
Just a minute. Past application?
Yes.
Custody?
Custody, my lord, 28/5/2022.
Charge sheet under section?
Charge sheet under section 302.
Name of the deceased?
Babu Pradhan.
Date of occurrence?
Date of occurrence, my lord, 23rd/10/2019.
Eyewitnesses are there?
Eyewitness, my lord, one is Sushant Jena.
कौन पूछी?
In that case, my lord, one of the who accused your lordship had this matter, that is BLPL number 3171 of 2021, my lord. That is disposed upon dated, my lord, 24/9/2021, my lord. That order is not available. That is the clear order your lordship have.
May I read that statement, Miller?
Kar?
Sushanta Jena, eyewitness.
Yes, my lord. I have Sushanta Jena. I have read it.
No, Mr. Tripathi.
Yes.
I have taken into account that I have mentioned like this, that in the meantime, the eyewitness Sushant Jena has been examined as PW2 during trial, and he has not supported the prosecution case. And even though it is the prosecution case that the deceased made oral dying declaration before the doctor, that is Dr. Bigneshwar Panigrahi of CHC Saragada.
Yes.
But the said doctor being examined as PW1 stated that on 23/10/2019, the deceased came with multiple injuries on his body and his condition was very serious, and after giving him first aid treatment, he was referred to MKCG Medical College Hospital, Barampur, for further treatment, and the doctor has specifically stated that he has not ascertained from the injured about the detailed history of the injury on his body, and he has also not recorded the dying declaration of the injured. So that is how it is detailed discussion is there.
Yes, ma'am.
So if your eyewitness is not supporting the case and the doctor who stated to have recorded the dying declaration is giving a different version, then what can be done?
Brutally attacked Miller, 38 injuries are there.
So that's all right, but unless there is material now against the petitioner, 38 injury, it's a really serious one, and but you are to bring materials against the petitioner for his implication. You have already detained him since 28/5/2022. this accused was not there in picture when this he was apprehended subsequently. I think.
Yes.
This was in respect of the co-accused persons who are facing trial, the
Yes.
earlier trial.
Yes.
What has happened in their trial?
Trial, my lord, case is committed, but trial is not commenced, my lord.
No. About the co-accused persons who are facing trial, whose evidence you produced and I verified
Yes,
it
my lord.
and
That is
released.
I am not
गंगा
in
साहू जो बेल ଦେଇଥିଲି ମୁଁ ST केस नंबर 33 of 2020 रे
Yes, my lord. That
से
is
केस रे कोन हला रिजल्ट किछि हेलानी ना पेंडिंग अछि
pending ଅଛି. All the co-accused persons already released on bail. That is one of the.
All right, heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 28/5/2022 and he has been charge sheeted under section 302 of the Indian Penal Code. The occurrence in question stated to have taken place on 23/10/2019, and though it is the prosecution case that one Sushant Jena is an eyewitness to the occurrence, but during the trial of the co-accused persons, the said Sushant Jena was examined as PW2 and he didn't support the prosecution case. And though it is the prosecution case that the deceased made oral dying declaration before the doctor, namely Dr. Bigneshwar Panigrahi of CHC Seragada. But in the trial of the co-accused persons, the said doctor being examined as PW1 stated that on 23/10/2019, the deceased came with multiple injuries on his body and his condition was very serious, and after giving first aid treatment, he was referred to MKCG Medical College Hospital, Barampur for further treatment. And the doctor also specifically stated that he had not ascertained from the injured about the detailed history of the injury on his body, and he has not recorded the dying declaration of the injured. The learned counsel further submits that though one Tukuna Pradhan is another material witness of the prosecution, but the said witness being examined as PW5 in the trial of the co-accused persons has also not supported the prosecution case and declared hostile. And taking into account these features, the co-accused Ganga Shah was directed to be released on bail by this court in BLAPL number 3171 of 2021 as per order dated 24/9/2021. He submits that other co-accused persons have also been enlarged on bail, and therefore the bail application of the petitioner may be favorably considered. Learned counsel for the state has produced the case diary opposed the prayer for bail. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, the fact that the eyewitness to the occurrence being examined in the trial court in the trial of the co-accused persons has not supported the prosecution case, and the doctor before whom the oral dying declaration was stated to have been made has also stated nothing in that respect in the trial of the co-accused persons. Further, taking into account the release of the co-accused persons on bail and period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail allowed. ଆଉ ଖାଲି ନବା
ସେଟା ଯେତିକି ମେନସନ ଖାଲି ସେତିକି କରିବ ନା ସିରିୟଲ କ୍ୟୁ
ନାଇଁ ଯୋଉମାନେ ଅଛନ୍ତି ତାଙ୍କ ସେ
ମେନସନ
ନମ୍ବର
ଅଛନ୍ତି ଏଗୁଡାକ ଅଛି ଫାଇଲ ଗୁଡାକ
जोड़ा अच्छी से उड़ा
जोड़ा
लिख
मगी माने आज मेंशन करतले
आउ जो माने देई नंती नंबर अबिया जदी अछंती
आगे
सेती नंबर देई दियंतु सेती केवल लिस्ट करे दवा जो माने से जो लिस्ट देबे ए जो ये रो सेती
काली पर्यंत तो अछि वीकली 3 दिन होइतला ए लिस्ट 3 दिन
ए मैटर टा अछि न से जेती की मैटर कहिबे जो माने देबे सेती गोल बुलेई थिबो सेती की डाकिबो हला देबे देबे से देबे बर्तन काउंसिल माने त नंबर देबे ना तापर से देबे